Paul Caneiro, it's indictment 19-020283. Can I have the appearances of counsel for the record?
Your Honor, Assistant Prosecutor Nicole Wallace on behalf of the state.
Good morning, Judge Chris Decker, Assistant Monmouth County Prosecutor for the state.
Good morning, Your Honor. Monica Mastalone on behalf of Mr. Paul Caneiro, who's present.
Good morning, Judge Andy Murray, Mr. Caneiro.
All right, good morning, everyone. Good morning, Mr. Caneiro. I did not want to bring the jurors out yet because there was an issue. Can I have the attorneys up here for a second? Ladies and gentlemen, if you don't mind, I have to deal with an issue, so I'm going to ask everyone to clear the courtroom for a minute. I will tell you all this, that I'm clearing the physical courtroom. I'm not turning off live stream. I believe next door is live stream. I believe it still is. I'm not sure. Do we know that? Anyone know?
Which one? Should be.
Right next door?
The 309 is no longer.
So it's not being
I
on,
can-
but you can watch it on the New Jersey Judiciary. I just can't have you physically in the courtroom with what I need to do right now. So I don't want you to think that you can't watch it somewhere outside. You just can't watch it in here, okay? And I'll bring you back in before we start. I'll take a break so that you guys can all come back in. I wouldn't do that to you.
Thank you.
I don't think it can answer because it doesn't.
Just to make sure.
It's okay. Yeah, I'm good.
I'm gonna use my telepathic.
Sure.
No.
Yeah, just number 9. Put him right in his regular seat.
Yep, and the bus stop was moved.
Morning, sir. How are you?
Morning, good.
So, something came to my attention in reference to, on Wednesday, walking out from the courthouse at the end of the day, that there may have been some conversation that went on between yourself and a sheriff's officer. And I wanted to just hear it from you, if there was any conversation. The way it was relayed to me is that it had to do something with the photographs that were observed on the screen. If you recall, do you recall having some form of a conversation with the sheriff's officer
Yes.
about that?
Yeah.
Okay. Could you tell me what the conversation was, please?
Let me think. Oh, boy. Jeez. I probably made reference to the fact that, that was something about the trauma of the photo.
Okay.
And I think I might have said something to him like, I guess this is nothing new for you guys. You probably see this once in a while. I think it was something to that effect. That's what I recall. I don't.
Okay, that's fine. So, when you say the trauma of the photo, tell me what you meant by that when you said that.
The trauma that those folks might have probably experienced.
Okay.
And
So
how-
the trauma to them?
Yeah.
Okay. Tell me how, when you saw the photos, if at all, how it impacted you.
Just sadness.
Okay. Now, we discussed, if you remember, one of the open-ended questions, we discussed this particular issue.
Right.
Because we foreshadowed that this would be something that would come up. And it's my recollection that every one of the jurors had indicated that they would be able to put any emotion aside and be able to still decide this case based upon all the evidence
Correct.
and not based on the photos. I just want to make sure you are still comfortable, that you saw what you saw, and that's fine. If you are in any way feeling any sort of way just by looking at those photos, I need for you to tell me now, because obviously it's important to both sides here.
No, I think that happened, and in that moment that happened, and then I was like, okay, just cleared it out. It was like, okay, that's what it is, and just move on. I tend to do that. Things can impact me, and then I'll process it, and then just go back to square one, so it doesn't like linger.
Okay. So, whatever that trauma was to the victims in this case, I need to know that your emotions that you had, even if you put them aside, that you would be able to still decide this case, because you have to decide not only that these individuals have died, and also that who the individual was who did this. So I need to make sure that you still have an open mind as to all of the evidence in this case. You're going to evaluate all of it and not just the fact that you're looking at those photos. Are you going to be able to do that?
I feel like it will. Yeah.
Okay. I want to get a little bit more from you if you don't mind.
Sure.
I don't know if it applied to you when we had those voir dire questions. Yeah, if you don't mind.
Folks, can you keep it down, please? Thank you.
I don't know if it applied to you or not, but sometimes when people would answer my questions when we were going through voir dire, if they gave me an answer that maybe it could mean something else, I would ask it again. And so I'm not trying to be disrespectful. I heard you, what you just said, but I just want to make sure. I need to know, and both parties need to know, that the photos are not going to impact your overall analysis in this case. So can you say that with certainty that you can do that, or are you still feeling like, yeah, it's still bothering me?
No, I can say it with certainty, yeah.
Okay.
I mean, it's just, when it hits you, it's like, I mean, there's lots of things through life where if I don't hold it in that moment and then be able to move on, that I'm just captured into the past and I'm ready to move on.
Okay. All right, so you feel like you could still be fair and impartial, both to the state and to the defense?
Absolutely.
Okay. So now let me ask you this. That conversation that you had with the officer, was there anybody else that was a part of that conversation?
He and I were on the back of the line. We were just together.
Okay, so there was nobody else there? And can you tell us about that, when you talked to him, was it in a high voice, was it a low voice, meaning that?
Soft.
Soft?
Yeah.
Okay. Did you feel, based upon what you saw during that conversation, that any of the other jurors heard what you said?
No.
Okay.
I made sure I was far enough back because I didn't want to.
Okay. Let me now take it past the sheriff's officer for a second. Understanding how you felt on Wednesday night, were you able to continue with complying with the charge of not talking to people that night about it or talk to anybody else about it? You had to kind of keep it to yourself. Were you able to do that? If you weren't, I understand. But
I mentioned a couple of things to my wife about it was a heavy day.
Okay.
That was about it.
You just said heavy day?
Heavy day, yeah.
Did you say anything more than that?
I said that they showed photos today and it was really impactful.
Okay.
And she wanted to know more. I said, but she goes, nope, I know you can't talk about it.
Okay. Did she make any comments to you as a result of what you said?
No.
Okay. All right. Is there anything about the conversation that you had with your wife that you feel that could impact you and your ability to be fair and impartial in
Oh,
this case?
no, not at all.
Okay.
Yeah.
All right. Separate and apart from this conversation, is there anything else that has happened during the course of this trial? Any emotions that have come up that would affect your ability to be fair and impartial?
No.
Okay. Do you feel like you can sit on this jury and decide this case, continue on?
I do.
Okay. Any doubt in your mind?
No. I mean, even when Wednesday happened, I was still locked into like objectivity. It was, so yeah, I feel competent.
Okay, great. Thank you, sir. This is between the four walls, so if you don't mind, we're going to keep this here. I'm not going to say anything to them, so please don't tell them either. And let me ask you this, just to round it out. Have you heard anyone else talking about the trial or anything else, or make any comments to you about those pictures or anything?
Folks in here?
Yeah.
No.
Okay.
Just, people are just, you got looks and we're like exchanging information just through our eyes. That's it.
That's it?
Yeah.
Okay, but no one said anything about it? Okay. All right, you can go back in the jury room. Thank you,
Sorry
sir.
for
No, there's nothing to be sorry about, sir. Thank you, though. I appreciate your honesty. Anything anyone want to put on the record? I feel comfortable with what he said.
Same for the state, Judge.
Okay. Defense?
Nothing at this time, Judge.
Okay. For the record purposes, after listening to juror number 9, I found him to be very credible in his responses to me. I found that under the circumstances, the pictures, they showed what they showed. And we, as the attorneys and the court, we looked at question number 1 to the jurors and asked them specifically because we knew that these photos could have impact. This juror remained consistent with what his answers was back during voir dire. I don't have any concerns about him and his ability to be fair and impartial in this case. I do not find in any way, shape, or form that there's been any impact on any of the other jurors. I find that the sheriff's officer and the juror were back away from the rest of the jurors, that the other jurors didn't hear those 2 comments that were made. And based upon that, I'm going to allow juror number 9 to continue on with our case, and we'll see where, if he ends up being a part of our case or not. Nobody knows until the alternates are picked after the charge is given to the jury. With that being said, is there anything else we need to do before we go back and bring the jurors out?
No, but Judge, I just need to remind the court, the state needs to rest.
No, I do. I remember that. Okay. But anything other than that?
No, sir.
Anything else from the defense before I bring them back out? Okay, I just don't want to bring them out and then us come right to sidebar in 2 seconds. So if there's something, let's just do it now. We're good? Okay. All right, we can bring them out. Thank you.
Really excited. Come on out.
See, I've been out here for a while.
You beat us for once.
It would have been fun if you guys knocked on the door and said that you were ready. Next time.
I didn't know we were allowed.
You got it. All right, we're just going to allow everyone back in. Did anyone see we may get snow again this weekend?
Wednesday's snow day.
Isn't it enough? Didn't we get enough? We can't get rid of the old stuff.
I thought you were going to indict somebody, Mother Nature or something.
Yeah, well, listen, Mother Nature's not listening. It's kind of like the story of my life. Nobody listens to me. All right. Let's just give it one more second. I apologize. I should have done that before I asked you to come out. Okay, we're back on the record. I already put the caption on the record earlier. So with that being said, I'll turn it over to the state.
Thank you, Judge. Subject to the moving of evidence, the state rests.
Okay, the state rests at this point in time. At this point in time, we'll move over to the defense case. The defense can call their first witness.
Thank you, Your Honor. The defense would call Dr. Jack Gould.
Good morning, sir. Just watch your step as you're coming up. If you don't mind, sir, if you could put your left hand on the Bible and raise your right hand for me. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, and once, you can get seated, get comfortable. Can you state your full name for the record and spell your last name, please?
Jack Gould, last name Gould.
Sir, I'm just going to ask for you to do me a favor, okay? When you speak, when you're testifying, please make sure you keep your voice up. Jurors number 15 and 16, they got to be able to hear everything that you're saying, so just keep your voice up, okay?
Yes, sir.
All right, thank you, sir. All right, when you're ready, Ms. Mastalone.
Thank you. Good morning, Dr. Gould.
Good morning.
Can you please introduce yourself to the jury?
Stand up.
Oh, no, you can remain seated.
My name is Jack Gould. I'm a local physician in Monmouth County.
And what is your educational background?
I did my undergraduate work as a microbiologist at Rutgers College. From there, I worked in the pharmaceutical industry and then went off to medical school at the University of Medicine and Dentistry. And then I did my residency in obstetrics and gynecology at Monmouth Medical Center.
And do you currently live in Monmouth County?
Yes.
Who do you live with?
I currently live with my wife, Pam Gould.
Okay, so I want to first talk to you about how you know the Caneiro family. Do you know Paul Caneiro and his family?
Yes.
And who is in Paul's immediate family?
Wife Susan and two daughters, Marissa and Katie.
And how do you know them?
They were my neighbors for 23 to 25 years.
Okay, and when did it start? When did you first meet them? What year?
Met in the spring of '96, and they moved in approximately 6 months after we moved in.
Okay, and when you say neighbors, where was your house physically located in comparison to Mr. Caneiro's?
They were directly, our back sides of both our houses, we were directly behind their house.
And what was your address at the time?
19 Oxford Drive.
That address may sound familiar, so let me just ask you this. Were you involved in this investigation at all?
Only in the fact that I had been requested to offer video surveillance for my cameras.
And did you ultimately provide the surveillance to the detectives when I asked?
Yes.
And we've seen that. Were you involved in this investigation in any other way?
No.
And was there anything with respect to the investigation that you would have added?
Yeah, it was kind of odd because when all this was going on, and this would be on the 20th, I was actually in my office watching, because I had cameras, watching what was going on, and they were going from one backyard to the other backyard, back and forth, and I realized they were talking to my wife, and when they pointed at the cameras, I kind of realized I'd be getting a visitor at my office. They showed up, they asked for the video information, but they never actually even asked if I had known Paul. They never asked any questions about it, and our backyards were kind of odd because we had a little walkway with pergolas and kind of grapevines, and they were putting up crime scene tape, but they never asked what was with the connection between the 2 yards, which was kind of odd.
Was it like a custom?
Yeah, it was custom pergolas and kind of made it look nice so that families could go back and forth easily.
Okay. So let's talk about that information that, I want to talk about the information that you have about the Caneiro family. But since you mentioned the surveillance cameras, I just want to talk about that briefly. Who installed your cameras, your surveillance system?
I did the actual installation of the cameras, and I did the hardwiring of all the coaxial cables to the main DVR that I had set up. Unfortunately, once I had it all set up, I couldn't get it to stream through the router, the modem. I just couldn't get it to actually work. So I contacted Paul and had him come over to do all the internet protocols or whatever needed so that I could stream it through the firewall.
Okay, so was there like was there any type of system that he put in place for you?
Along the way, he had set up for internet security. He did a external hard I guess it would be a router firewall that I used Square One to manage, just so I didn't have to worry about anybody hacking into my system. Unfortunately, I didn't understand how it worked. He did, so I would always have him take care of any problems that occurred. And one of them was trying to get the video cameras to work.
Was there something with like an acronym that he used?
He set up it's a DDNS, and I know it has to do with changing IP addresses, but I don't understand it. He did.
Okay. So you mentioned you don't understand it. Is this something that's is it simple or is it more complex?
To me, it was complex.
Okay. And did Mr. Paul Caneiro ever set up any access points in your house anywhere?
He set up an access point over our garage because it was too far away from the antennas for our router, and this way my wife had her office up there, and it allowed us to have better internet access at that end of the house.
And so returning to the Caneiro family,
Yes.
I want to focus on that. When you mentioned you first met the Caneiro family in 1996, how soon after they moved into their home at 27 Tilton did you meet them?
I actually saw the day they moved in, and I probably met Paul the next day or within 2 days. He was in his backyard, so I went in my backyard just to kind of chit-chat with him.
And how did that conversation go?
It actually went very well. I'm a firm believer after about 5 to 10 minutes of talking to somebody, you can get a good flavor if this is somebody you can continue a conversation with. And I could. It was very comfortable. We had very similar likes and a very similar personality. You know, sense of humor actually matched very well.
And did you see anyone help the Caneiro family that day move in when you saw them?
When I actually saw Paul was coming in with he had his brother Keith with him, and Keith was carrying some stuff in with him.
Okay. Now, over time, can you explain to us how your relationship developed with the Caneiro family? And I'm referencing Paul, Susan, and their daughters at this point.
It turned out that Paul had 2 daughters, and I had a daughter and a son, and they were both, all 4 of them were within a year of each other. So there was Marissa, my daughter, and then Katie and my son. So they were all pretty much in the same age bracket. They were going to be going to the same school system. And they started, because the backyards were next to each other, were playing with each other constantly. And then because of that, my wife and Susan were around. They would actually start supervising the children. And then on the weekends, when Paul was around, we would all get together. The children would play, and it was almost like a common backyard. They would run back and forth from house to house, and we would kind of just sit on a deck and just watch them play. And as time went on, you get friendlier and friendlier, and you get to know each other a lot better.
So, over the years, how often would you say you saw the Caneiro family?
In the summertime, especially when the children were off in the warmer weather, it would probably be almost every weekend or every other weekend. Somebody would either have a barbecue, even if it was just throwing hamburgers and hot dogs on the grill. Because the kids were out playing, it was better to be outside than inside. So every week to 2 weeks.
And so, would you consider yourself and your family close to Paul and his family?
It got to the point where it would be like considered extended family.
And did your families ever become close to the extent that you would celebrate holidays together?
Yeah, we got in the habit very early on. All Christmases would be celebrated at Paul's house, mainly because I'd be on call a lot for Christmas, so I may or may not be there. So we did the Christmases over at Paul's house, then New Year's, we would alternate one house to the other. He would host it, or I would host it. And on these events, you could invite anybody or any family members, anybody. And then as it got warmer weather, Labor Day, Memorial Day, we would have outdoor barbecues, and either he would host one or we would.
Now, who else would typically be at these barbecues or the holiday events?
A lot of times we would be there, Keith would be there with Jen. And early on it was just Keith and Jen, but as time went on they had children. So then Jesse and Sophia would be there. Sometimes if Katie or Marissa had friends, they would come over. My children would also be over there, and if they had friends, they would come over. Occasionally the parents, I know Paul's parents would be there from time to time.
And do you know, Jim and Stacy Pritchett,
Yes.
would they be there as
They
well?
would be there also.
Did you ever see Corey at any of
Yes.
these gatherings?
Corey was there, but not as often as everybody else. So I would say he was there maybe 10 to 15% of the time. He wasn't there all the time, but he would be there occasionally.
And, who is Elisa?
Elisa was Corey's girlfriend, which led up to, I think they got married at some point in time, but I don't know when.
And how often did you see her?
If I saw her once or twice in the 23 years, that's about it.
Now, in addition to holidays, you mentioned, I think, barbecues and other types of like Labor Day, Memorial Day events. Did you ever socialize with the Caneiro family in any other capacity?
Yeah, especially because the kids really got along great, and we got along great. We did go on a couple of vacations to the Outer Banks in North Carolina, and we also went to Turks and Caicos, both families together.
Okay. Now, based on how well you knew Paul, how would you describe Paul?
Very well educated, very well read, easygoing, someone you could have a conversation on almost any topic, and you could have an ongoing conversation. Calm enough that you could make jokes and not worry that you offended him. He kind of rolled with the punches and had a very pleasant personality, never got angry, never got upset. And, you know, he was good with the kids. It's an enjoyable experience. It's good.
Would you describe Paul as a helpful person?
Most definitely. He was very good with his hands, and he had a pool. At one point in time, he put a pool, and we had a pool. So if I ever had pump problems with my pool, he would come over and essentially show me how to adjust, you know, my pool. If I had any electrical issues, he would come over. And if I had troubles with IT stuff, he would actually run the wires and then, you know, call actually to the company and switch things over, just so that instead of using coaxial cable, we would use Cat5. And if I had problems outside with drainage, he would come over and talk to me about how the best way to run drainage things.
And I think you mentioned that when you were describing Paul, he like more of a calm personality. Can you
Yes.
explain that more?
You know, when you have young kids running around doing what young kids do, he never raised his voice. I never had an argument with him. We never argued about anything. Never heard him argue with anybody. You know, he was just a very calm individual. I don't know how the better way to say it, but
And now you mentioned that you also had the occasion to meet Keith and Jennifer. It sounds like many times.
many times. We never went on vacations with them, but they were always over at Paul's house, so we did socialize with them frequently.
And based on your observations and your experience with the Caneiro family, including Paul, Susan, their daughters, and Keith, Jennifer, and their daughters, how would you describe the relationship between Paul and Keith?
Exceptionally close. I mean, some people would even say they were like fused at the hips. They could talk about many different things, always joking, laughing, in a very close, caring relationship. You could feel that they cared for each other. And even if they were partners in a business, and even if they were talking about a client, it was a quick conversation, and then they moved on to something else.
And how would you describe, like, Paul, the way that Paul would speak about Keith, or?
Protective. And I remember, you know, if Keith ever had a problem with something going on at his house, Paul, and this happened once we were out at lunch, if something was going on at Keith's house, Paul would say, oh, as soon as we're done, we have to drive over to the house. He's got to set up something that was a pool timer that needed to be adjusted. Paul would drop what he was doing and go over.
So, was it your impression that Paul would, you mentioned earlier he was helpful. Does that include being helpful to Keith when he could?
Yes.
What about when Keith went back to school?
when Keith went back to school, I guess he went to Columbia, and I'm not sure if it was for master's or a PhD. Paul was very supportive. Paul was actually very proud of it. And it wasn't uncommon that Keith would contact Paul about, I guess, classes, things to do, if there was a project, just for advice. So Paul was very supportive of it.
And so I want to focus a little bit more now on the year of 2018. Was the summer of 2018 any different than any prior summer as far as the get-togethers and the being with family?
The summer of 2018, there were less get-togethers. I think between Paul and Susan, there may have been a marital issue or something, so I was working a lot, and I guess we didn't really have as much where we would go out to dinner as much. But Paul still, on the weekends, would still have barbecues, so we would still get together in that respect.
So would you still spend time with Paul and Susan and the girls as a family
Yeah,
that summer?
yeah.
Okay. And to your knowledge, you mentioned the marital issue. Did Paul and Susan still get along?
Yeah.
Did you ever hear Paul say anything bad about Susan? Or
Objection, Judge.
Sustained. Sustained. Don't answer that question. It's hearsay.
Did they ever express any type of,
Objection.
Sustained. Express, you're asking for what he has heard from others, so it's sustained. Hearsay.
can we approach?
Sure.
During the time that you knew Paul and Susan living at 27 Tilton, was there a point in time where there were renovations to their home?
Yes.
And can you tell us a little bit about that?
There was a few renovations. The first one that I remember was they were doing work on their bathroom, which was putting in closets and redoing it. So they renovated that. And then as time went on, LED lights became the fashion, and you could adjust the brightness. So he had an electrician guy, and they were changing all the lights to LEDs with special switches so that he could adjust light paths. So if one of the daughters came home in the middle of the night, they could just press a button and there'd be a light path, so they didn't have to turn on and off lights the whole way. So he was switching all that over. He also had another guy the guy that did our pergolas, was taking down sheetrock and doing insulation indoors for sound, sound silencing insulation. So soundproofing, I guess would be the best way to say it. So he had a lot of rooms soundproofed.
What about anything with woodworking?
Yeah, they did a lot of custom cabinetries. So I know in the bedroom, when you do an entertainment system, he had custom entertainment systems built. And that was the same guy that did, I think, the pergolas.
And I want to draw your attention to November 19th of 2018. Do you remember that day?
Yes,
Was there anything special about that day?
that's my wife's birthday.
And did you go out that night for her birthday?
Yes.
Okay. And after that, what's the next thing that you remember?
We went out for, I guess, dinner and drinks. It was a nice evening. You go to bed. And then somewhere around between 5 and 5:30, maybe 5:20, we got a phone call from Katie Caneiro, Paul's daughter, that their house was on fire. She didn't know much details, that in case the fire had spread, because we had a big oak tree between the yards, grab our dog, grab your valuables, get dressed and get out of the house. So we did. And then we left our house and we were at the top of our driveway, which saw the back of their house and saw the house on fire.
Okay, and did you see them at all that morning?
No.
And when was the next time you saw anyone from the Caneiro family?
Later that evening, it may have been, Susan came to our house because she was going to be staying with our house.
And obviously, a lot of time has passed since 2018.
Yes.
Are you still close with the Caneiro family?
Yes, very much so.
Okay, thank you.
Ross?
Mr. Gould, good morning. How you doing? Just wanted to ask you a couple of questions. You mentioned Columbia. Were you talking about the university or the country?
No, the university. I think
Oh, the
we went to
university.
Columbia.
Because that's where Keith went back to school, correct?
Yes,
He got his MBA, I think, right?
I think so, yes.
Okay, so when you first met Keith and Jen, they didn't yet have kids, right?
No,
Okay, and eventually they did have kids,
Yep.
correct?
yes,
Sophia and Jesse, right?
Mhm.
So you knew Sophia, you knew Jesse?
yes,
Okay, and were they at your house at times?
yes,
Okay. Now, you understand with respect to, I guess you had interactions with, where it would be you, it would be Keith, and it would be Paul all together, correct?
yes,
And you described their relationship as being extremely close. They were, I think you said maybe joined at the hip or something like that.
that's a nice way to describe it, yes.
Now, Corey was a bunch younger than Keith and Paul, right?
7 years, I think,
Yeah, 7 or 8, right?
in that ballpark, yes.
Because Keith and Paul are like 1 year apart, right?
Mhm.
Okay. So there was a significant age gap there, right?
Yes,
And Corey wasn't even married yet, right? When you first met him, you said?
when we first met him, no.
Now, you talked about electrical issues or electrical work that was being done and how Paul would go over to Keith's house and he was helping him out with some of these electrical issues and things like that, right?
I don't know if it was
Objection, that's
specifically
not what
electrical
he
issues.
said. He said it was a pool issue.
He did say something about electrical, so I'm gonna.
That was Paul's renovations.
Your objection is overruled. Whatever you remember is what you said is what matters to us. What was it about electrical that you recall that Paul would do? That's all we want to know.
Paul's house, he had some guy coming in, changing all the light bulbs to LEDs and all the light switches so that they could be operated through a app on his phone.
Paul was obviously very tech savvy, correct?
Most definitely,
Probably more than you, right?
most definitely.
I'm sure more than me.
Objection.
Sustained.
He was more tech savvy than most people you knew. Is that accurate?
Correct.
And when you had issues with your cameras, he was able to come over and try to figure it out, right?
Either would come over, or if I had computer issues, we actually had overlapping wireless networks. Sometimes he would just fix it from his patio.
Remotely?
Yeah.
Okay. And you said he would go over to Paul, you did say he would go over to Keith's house sometimes and help out with stuff though, right?
Yes.
Okay, what kind of stuff?
The one example I can tell you, just because I remember, I was with Paul, we were out at a restaurant having lunch, and he goes, I got to go over to Keith's house and adjust, I think it was either a light or a setting to the pool. And he goes, do you want to come on over with me? And I said, yeah, I'd love to see the house and get a tour.
So you've been to Keith's house, correct?
Yes,
And you've been to Paul's house, I imagine, many times, right?
many times.
And when was the last time you think you were there prior to the fire?
At Paul's house.
Yes.
Probably September. Well, the fire was September, October, somewhere in that ballpark. I don't remember the exact day.
Okay, I understand that. You were in the basement during the course of your times at 27 Tilden?
Yes,
Okay. And were you in the basement, like, close in time to November 20th of 2018 when the fire happened?
probably the last time I was down in the basement would have been in the summer, maybe, but not close to the fire.
Describe the basement for us.
You would go down the steps. To the right was a area, I guess, where the kids would be playing in. They had a play area. If you went over more to the right, there was an enclosed area which he had kind of an entertainment area with a TV and music. If you went down the steps and you turned to the left, you went through doors, and that's where he had, I guess the best way to say it would be like a hobby doing gunsmithing, you know, so he kept the gunsmithing equipment down there.
Okay.
And then if you went further down, there was another area where he had some water purification systems and storage cabinets.
When you say gunsmithing, what do you mean?
He owned firearms, and sometimes if they needed to be worked on or looked at, he would actually clean them, repair them, take them apart.
Did you ever shoot firearms with Mr. Caneiro?
Yes.
Okay, where'd you do that?
At that time, I think Paul had 2 memberships,
Okay.
and they were more outdoor ranges, and I had a membership in Lakewood at an indoor range.
At Sure Shot?
Yeah.
Okay, did he have a membership at Sure Shot?
You know, I don't remember if he had a membership because you could bring guests, so I'm not really sure.
Those outdoor ranges, there's an outdoor range like almost like across the street from Tilton Drive, right?
Yeah,
Gun Club Road, right?
Mhm.
Okay, so that's nearby, right?
yes.
Did you ever go there with Mr. Caneiro?
No, I had been there for a safety course, but I did not go with Paul.
Now, can I have the back table for a moment? Dr. Gould, I just want to show you a couple photos, just for context, if you don't mind. Let me show you S1A, slide 3. And I'm just going to ask you if you recognize what that shows. And do you recognize that area?
Yes,
And what's that?
that's the front of Paul's house.
Okay, and what's in the back here?
Right here?
Yeah.
My house.
That's your house, I just want to make sure. Can I have S1A slide 3? It's going to be on the screen in front. Okay, so, Doctor, you just pointed it out here, but could you just explain what we're looking at here? And you can use that pen if you'd like.
Right, this is the front of Paul's house, and this is the back end of my house. The northern side would be over here.
I don't know why that thing is not working.
That's okay.
It usually does.
Oh boy.
Our screen is. So what we're going to do is we're just going to look up here. The house that's kind of in the majority of the photo is 27 Tilton, correct?
Yes,
And then just like kind of over top the garage with the 3 windows on the left, that's your house in the back, right?
yes.
Okay. And just, if I could, I'm going to show you slide 6 of S1A. Do you recognize that?
Yes.
And what's that show?
That is actually the northern side of Paul's house where the garage doors are.
Okay. So north is up to the left, right?
Yes.
Your house would be east, right? Okay, can I have slide 6, please? Okay, so when we're looking at that photo, if you could just kind of just explain, now that the jury can see it.
Okay. This is the back where Paul's garage is. My house would be back here. Way up here was where my wife's office was, and this is the other part of our house.
Okay, all right.
Isn't that working at all?
It's not, Judge,
I'm
I'm sorry.
talking to Dave now.
All right.
It's okay. Sorry, it's not working. These are Mr. Caneiro.
Technology.
Sorry. Dr. Gould, those are Mr. Caneiro's cars in the driveway, right?
They're his cars, or daughter's cars,
Oh,
but they're owned by the
they
Caneiro
belong
family.
at that residence?
Yes.
Okay. And your cameras are on the back, you have cameras, you had a bunch of cameras on your
Yes,
house, right?
yes, I did.
But there was 2 on the back, right?
There was a camera that was here. I'm trying to think, this was the main camera. I did have another camera, but it was inside the house, facing outward, and there was a camera on the other side of the house. When I was installing the cameras, I had asked Paul's advice, and every main entry point had a camera on it.
Okay, I'm going to stop us for a second. Can you guys just go in the jury room for a second? Don't discuss this case, don't do any research. I want to fix this issue so that, I want to make sure that we can get this captured. Doctor, you can just, you can take a seat. Our IT person. just want you to know I could have fixed it myself, but I didn't want to show off.
Sure. Would you turn it off, turn it back on again?
All right, we're good to go now. Mr. Decker, I'm going to ask for you to step back. Yeah, and I'd like for you to step back to the picture before, because there was conversation about that we did not capture, so that the record is clear. I'd appreciate it if you do that.
Yes, sir, Judge, of course. Can I go back to slide 3, please? Doctor, we're going to go back to that first slide, number 3, which is on the screen now in front of you, correct?
Yes.
Could you just put an X on like the 27 Tilton residence? There you go. And then when we talked about your house, can you put like a Y over top or something? Okay, great, thank you.
All right, so we'll mark that is slide 3. I don't know what point we're on with that one. It's because a couple other people used it. Do you know, Anna?
I can hear you. There's a delay in my team.
Oh, that's okay. So I just want to confirm that it's 3 point something. I don't have my latest for that slide.
Your Honor, it's 2.
3.2? Thank you. All right, so 3.2. I'm sorry, go ahead.
No problem. Could we go back to slide 6 now, please? So we're looking at S1A, slide 6. And again, you referenced where your house was. Can you put a Y over there again? Thank you, Doctor. And then this is the garage, I think, of 27 Tilton, right?
Yes.
You put like a G there or something? Great, thank you. And then you said that the 2 white cars, they belonged there, correct?
Yes.
Okay, you didn't know which one was specifically whose, but they both
No.
belonged at the residence?
Yes.
And you referenced one of the cameras from the back of your house that was like on the back of your house, correct?
Correct.
Could you put like a little circle, like I
I
know you
had
may not be able to see it,
A
but,
camera right here,
okay,
and there was a window here, and on the inside, there was a
Okay.
camera that faced directly out.
okay.
But
Yes, you want to go a little above it with an arrow, maybe it'll actually mark better. There you go.
Perfect.
Thank you, Doc. And with respect to that camera footage, you testified that you ultimately, you gave it to the police, right?
yes,
All the cameras from your home?
whatever they asked for.
Okay, and ultimately, they took it and they ultimately looked at it, you imagine, right?
Yes.
Did you look at any of the footage prior to turning it over to the police?
No.
How about afterwards?
Yes, but it wasn't until a few weeks afterwards, just because being on call, and I just never really wanted to look at it.
Can we,
Did check it a few weeks later.
sorry. Can we just save that 6.3?
When you looked at it, did you see a car leave at 2:08 in the morning from that 27 Tilton driveway?
When they originally asked for the video footage, I gave them the original, but then they asked for another set. So I saw a car coming back on the first set, and it wasn't until maybe weeks later that I saw the second, what they requested for, and that's when I saw a car leaving.
So you saw a car leaving the driveway at 27 Tilton in the middle of the night?
Yes.
Early morning hours?
Yes,
It's about 2:08.
it would be time-stamped on the,
Then did you see the car come back about 2 hours later?
yes.
Okay. Did you see when the fire first became visible on the back of 27 Tilton?
Not when it, on the camera or in reality?
On the camera.
Yes,
Okay, you weren't up when the fire started, right? Okay. You weren't up when the time when the car left 27 Tilton?
no,
You weren't up when the car came back to 27 Tilton, correct?
correct.
And obviously, you talked about the relationship between Paul and Keith Caneiro, right?
Yes,
And they were close, correct?
yes,
They were a year apart, they were brothers, right?
yes,
But obviously, I mean, you'd acknowledge, Doctor, that you weren't privy to all their conversations, right?
correct,
Okay, and you weren't privy to all their, personal conversations, right?
correct,
As well as you weren't privy to all the inner workings of the two of them as they related to like owning businesses together, correct?
correct,
And you obviously mentioned Square One, right? Yeah, I'm
Right.
sorry, you just gotta say it for the record. And EcoStar, right?
yes.
And did you know the dynamics of like who owned how much of what?
No,
Okay, Paul never told you the dynamics of the majority versus the minority of, say, Square One?
You know, we were good friends, and I didn't really want to pry into his business affairs.
Okay, so you didn't pry into his business affairs?
No.
Okay, so you didn't talk about any loans he took or anything like that?
Objection, he indicated he doesn't know.
I don't know what the loan is for, if it's personal or if it's, if you know.
I didn't ask any questions or knew anything about loans.
So you weren't aware in November of 2018 anything about,
Objection.
He hasn't finished his sentence yet. What's the objection?
Can we approach Judge?
Sure, of course.
Doctor, just a couple more questions. What I was asking is that, is it fair to say that back in November of 2018, you weren't aware of anything regarding Mr. Canero's financial status?
The only thing I did know about was he had a disability policy, because I had one also, and they were very similar disability policies. That's the only thing I knew about.
Okay. You weren't aware of any phone calls the night before November 19th between Keith and Paul?
No, not at all.
I just wanted to, because you mentioned you knew Keith Caneiro, Jennifer, Sophia, and Jesse, correct?
Yes.
Doctor, I just want to show you what's been marked as S2 for identification.
Yes.
Do you recognize that?
Yes.
And what is that?
That's a picture of Keith, Jennifer, Jesse, and Sophia.
Can I have that published, please? Doctor, just now that it's in front of the jury, can you just tell us what that picture shows and who that is?
Keith, Jennifer, Sophia, and Jesse.
Keith, describe his hair for me.
Sparse.
Okay. He kind of had a shaved head. He kind of had a shaved head, right?
Yes.
Okay. And Paul has hair, correct?
Yes.
And he's had hair as long as you knew him, right?
Yes.
And Corey had a shaved head like that, right? Like Keith?
Pretty much the whole time I knew him, yes.
Yeah. Judge, can we just approach the 2 seconds?
Sure, can we turn the lights back on, please?
Sorry, Dr. Just trying to show you what's been marked as S501. Just, do you recognize that?
Yes.
Okay, who's in that picture?
Raise this up. Paul with his daughter, Katie.
Okay.
And either Minky or Kaya.
One of the dogs. Did you know the dogs?
Yes.
They bark?
Not much.
Okay. Now, does that, and I'm asking you whether you know, because you know them, does that appear to be a picture from the time frame that we're discussing, November of 2018 or somewhere in that time frame?
I couldn't tell you because it may have been before then.
Okay.
It may have been before then.
Okay. Do you recall whether or not that's what Mr. Caneiro looked like back in 2018, 2017?
I gotta be honest, I don't have the memory to go back that far to know how he dressed at that point. But I
Okay.
do know that's him, that's his daughter. I'll say, based on the daughter's age, she was probably in her early 20s.
Okay, and that's their deck, right?
Yeah,
Okay.
yeah.
Thank you, Doc.
And I'm sure pergola would be back there.
Oh, so you can see the pergola. on the
Pergola in
picture.
the gate, back there.
Great, thank you. Doctor, thank you very much, I appreciate it.
Any redirect? Okay.
Doctor, you mentioned obviously Sophia and Jesse as well just now, and I think the prosecutor talked to you a little bit about them. What was Paul's relationship with Jesse and Sophia?
Very good, fabulous. You know, by the time Jesse and Sophia were coming around, especially when they were, 8, 12 in that ballpark, his children had already been in their 20s. They were older. So it was kind of like having, I guess, kids again. So he especially loved Jesse because he had 2 daughters, and he he could do things with Jesse that he may not have done with his daughters. But he loved them very much. And again, whenever we had gatherings together, even between both our houses, those 2 kids essentially had free reign. And it would not be uncommon for Jesse or Sophia to run into our backyard, go into our house, where our kids' playroom was, and play with toys, and they would just go back and forth. So it was a very good relation, and he kind of spoiled them on the holidays. It's life.
And the prosecutor asked you a little bit about whether you had gone to the shooting range with Mr. Caneiro, and I think you mentioned that you went to a different shooting range at some point without Mr. Caneiro to take a gun safety course. Do you
Yes.
remember that?
That was many years ago, and it was down in, I guess, Ocean Township. It's Gun Club Road. It's mainly for skeet shooting.
So, just to clarify, did you have your own gun collection?
Yes.
And, how old were you approximately when you started owning guns?
I started at age 18.
Okay. So the fact that you owned guns and Paul owned guns, was that part of your, just one aspect of your friendship?
It was one aspect of the friendship that we could talk about and communicate.
And lastly, the prosecutor asked you some questions about your surveillance system and things of that nature.
Yes.
Did you ever employ or use the services of Square One to assist with any type of IT work?
Yes, when we had our first practice, everything was on paper, and that was being a thing of the past, so we were going to electronic medical records. So the whole office had to be set up for computers, both wired and wireless. We also needed a server, so we contacted Square One. I went through Paul, and they came over and wired the whole office. They set up access points for wireless, and they put in workstations for the receptionists, the nurses, people that would do the billing, and they put a server in. And then as part of that, now that it's a medical practice, it needed to be secured. So I had mentioned to him about HIPAA regulations. We had to make sure that nobody could hack in for information. So he also set up an external firewall. And again, not my technical knowledge, but whatever was needed in case there was a breach, we could refer to Square One for their expertise and our protection. And as part of that, we put a rider on because I would log in from my house to the office. Therefore, my house needed to be protected also.
Gotcha. And so just to, notwithstanding that one aspect of using their services to assist an IT issue with your business and your home, other than that, to clarify, your relationship with Paul and Susan and his family, as well as with Keith and Jennifer and their family, was it more personal or was it business?
More personal.
Thank you.
Any recross?
Just, obviously, Mr. Caneiro is very tech savvy, correct?
Correct.
He was able to do all that for your office, right?
Mm-hmm.
The
Yes.
access points, correct?
Yes.
Able to enable it so you could remotely access your home from your office and your office from your home?
Yes.
Thank you.
You can step down, sir. Thank you.
Thank you.
That's your step. How's everybody doing? Okay? All right. We'll call our, the defense could call our next witness. Hold on a minute. Did you say who you're calling? You didn't say who you were calling?
Miss Pam Gold.
Miss Payne? Oh, okay, ma'am, come on up. Just watch your step, please. If you could do me a favor, could you put your left hand on the Bible, raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, get yourself seated and comfortable. And once you are, can you state your full name for the record and spell your last name, please?
Pamela Gould, G-O-U-L-D.
Ma'am, I'm just going to ask you to do me one favor. During the course of your testimony, please keep your voice up. Jurors number 15 and 16 in the back corner over there, they need you here, hear you,
Okay.
okay? All right, thank you. Ms. Massalone, go ahead.
Good morning. Ms. Gould, can you please introduce yourself to the jury?
Good morning. My name is Pam Gould, officially Pamela, but I use Pam.
And what is your current occupation?
I am retired.
And what's your educational background?
I graduated from Montclair State College in December of 1984 with a bachelor's in business administration.
And are you married to Dr. Jack Gould, who we just heard from?
Yes.
Okay. So obviously we just heard from your husband, so we already have, background. We know that you and your husband were neighbors with the Caneiros for many years. So I just want to focus on the nature of your relationship with them.
Okay.
Generally, can you describe your relationship with Paul and his family and how it developed over time?
We were very, very close for 25 years or so when we were back neighbors. They moved in about 6 months after we did. Our children are all about a year staggered apart. So the kids became fast friends and we became fast friends. Over the years, we became closer and closer, really extended family.
And what kind of things did your family and the Caneiro family do together?
A lot of hanging out in our backyards, but we also vacationed together, dinners out, dinners in, movies. We went to a couple Broadway shows, traveled a couple times together as families, lots of barbecues in our backyards.
So did you consider yourself and your family close to the Caneiro family?
Extremely.
Okay. And did you consider them like family?
Absolutely. Extended family for sure.
And in the Caneiro family, who were you? How often would you see the Caneiros?
Susan and I spent much more time together than with the kids when they were younger, but Susan and I would spend maybe 2-3 days a week together, sometimes more. In the summer, we would just be out in the yard with the kids, but on average, probably 2 to 3 times a week.
Were there times when you would see her more than that?
Yeah, for sure. In the summers, we would basically see almost daily. If the weather was good, we'd be outside with kids playing. They had a pool, we had a pool. We would go back and forth between the 2 yards.
And since you were close with Susan and Paul and their family, and spent a lot of time together, including the summer barbecues and things of that nature, did you also have the occasion to spend time with Keith and Jennifer Caneiro and their family?
Yes.
And can you explain how you came to know them?
Well, they were always present for Christmas Eve, was always at the Caneiro house. So Keith and Jen were always there with some other people, on and off, whoever it was that year, but they were there every year for Christmas Eve. And then when we would just be in the yard, if it was a barbecue or one of the kids' birthdays or a 4th of July weekend holiday, they would come over and spend the day in the yard with the Caneiro family and my family.
And so based on how well you knew the Caneiro family, how would you describe Paul?
Paul is very intelligent, very well read, sometimes opinionated, but a very kind, giving soul.
And would you consider him like a helpful person?
Extremely helpful. He would offer up advice and physical help whenever there was a problem with our pool or our internet, which I'm sure my husband spoke about,
Yes.
that kind of stuff.
You mentioned, what was his demeanor like? What was his demeanor like?
He was very jovial and even-tempered.
Even-tempered?
Even-tempered, yes. Never saw him lose his temper, yell, scream, nothing like that.
And based on how well you knew Paul and Keith and the interactions, like the frequency you would see them and your interactions with them, I want to ask you about the nature of their relationship. How would you describe Keith and Paul's relationship?
Very close. Very close.
And can you explain more about that?
Paul was very protective of Keith, took care of Keith, that I saw personally, but we also heard stories of when they were growing up.
So I don't want to elicit any hearsay, nothing that anyone else said.
Okay.
Just based on your personal knowledge and what you know and what you've observed and what you've seen, is there anything else that you can tell us about just, either the bond between Keith and Paul or how close they were, things of that nature?
They were very close. They spent a lot of time together, obviously working together, but also outside of work. They spent a lot of time together.
And what about when Keith went back to school?
Paul was 100% supportive.
And do you have any knowledge of how Paul and Keith might typically handle disagreements with each other?
I believe they talked them out, never saw anything physical. Sometimes it would get a little contentious or tense, but it was always hashed out, and then they would pick up where they left off, go get something for lunch or dinner, and have a laugh.
And I also want to ask you about Paul and his relationship with Jesse and Sophia. How would you describe that?
Paul loved those kids like his own, especially had a very close bond with Jesse.
And when you say a close bond with Jesse, are you aware of any specific things that they would do together?
I know they did lunch dates from time to time, and you could just see the bond when they were together. They would just connect.
And are you aware of any renovations that Paul and Susan did at their house?
Yes.
And what was the approximate time frame of the renovations?
It was over the course of a couple of years. I don't remember what years those were, but it was over the course of a few years.
Was it like closer to, if you, just approximate, was it like after 2015 or around that time or
Probably
closer?
around 2015.
Around then?
I think so.
And you said over the course of a few years?
A couple of years, yeah.
Okay. And can you tell us, based on your knowledge, like what do you know about the renovations?
It was a full house reno, done room by room. Bathrooms, kitchen, new floors, sheetrock, moldings, everything was replaced and updated.
And how did Paul, like, when he would talk about the renovations, how did he express himself? Without saying what he said, but what was your general impression?
Oh, he was very excited. He was very involved he did a lot of research on all the products, and he was very excited about updating everything and liked to talk about it a lot.
And was there anything,
Sorry.
are you aware of a backpack that Paul typically had?
I know he had a backpack, yes.
Okay, and do you know where he kept it or where?
I believe it stayed in the car most of the time.
And I want to draw your attention to November 19th of 2018. Do you remember that day?
I do.
And what, if anything, was special about that day?
That was my birthday.
And did you do anything that day to celebrate it with anyone in the Caneiro family?
Susan came over in the afternoon and we had a cup of tea.
And do you know around what time that was?
Probably around 2:30 or so till about 4:30.
And to your knowledge, where was Paul at that time?
He was sleeping.
Okay. And do you know, to your knowledge, do you know why? Objection.
Sustained. I'm sorry. Come on up.
Based on how well you knew the Caneiro family, was it usual or unusual, either way, for Paul to be sleeping around that time?
It happened periodically. It wasn't a daily thing, but it did happen periodically.
Okay. And do you know why?
Objection.
Don't answer that. Ladies and gentlemen, can you go in the jury room for a second, please? Everybody can be seated.
And we're out.
So for the record, we're outside the presence of the jury. How do you know that he would be sleeping at times during the day?
Susan would tell me.
Right. And as to why he would be sleeping, how would you know that information?
Susan would tell me that he was having a headache.
Okay, all right. So that's all hearsay. I'm not going to allow those questions to be asked. So, Ms. Masalona, I had said it already at sidebar. We went back to it again. I'm ordering you not to do that, to go down that line of questioning now that we know for sure. We've heard the answer from the juror. So we will allow the direct to continue. I heard one go into the bathroom, so we'll just check that. As soon as they're not in the bathroom anymore, we'll bring them back out, okay?
Yes.
All right.
Can I just put my position on the record, which is simply that even if it is hearsay, it falls under the exception of state of mind and present like medical condition. I understand the court had a prior ruling with respect to the time frame of when Keith was on the phone with Paul that evening. And the court had a concern, I guess, about the indicia of reliability, but I think asking this witness generally, over time why Mr. Caneiro would be typically sleeping at a certain time during the day, and referencing like a medical issue, that was the reason, that there is an issue of reliability, because there's no reason for, like, that's the whole purpose of hearsay, is we don't want to elicit statements out of court that are unreliable, but this would be a reliable statement because we're just talking about generalities and over time, and this is earlier in the day, so I don't, you know, even if it is hearsay, I think it does fall under an exception, and I'll just end it there.
All right, Ms. Wallace, do you want to respond?
If a statement submitted is hearsay, that doesn't fall under the state of mind exception because the state of mind would not be relevant to anything. It's squarely hearsay. The defense filed 1,000 motions over the summer that this could have been hashed out then. The state filed motions to bring in certain hearsay that were heard. The state's position is that this does not fall under state of mind evidence.
Okay. Well, I'm not going to hold it against the defense for not bringing this out based upon certain case law that exists. However, I do agree that under the state of mind exception to the hearsay rule, I do not find this to be relevant to the circumstances here. I find that whether it's reliable or not, that's not the reason that the court is not going to be allowing this information. It's the question really is for this court is what is the relevance to this information as it relates to this case. I don't find it to, one, be relevant, nor, number two, do I find it fits under the exception of the state of mind and or any other hearsay exception. So therefore, I'm not going to allow that question to be asked. And ma'am, I'm going to also order you, now you're hearing me saying what I'm saying, you are not allowed to just elicit or just say that information.
Okay.
All right, because I'm saying right now that that information should not go before the jury, okay?
Yes.
All right, thank you, I appreciate that. So as soon as we have our jurors ready, we'll bring them back out. And I apologize to everyone for the little coughing fit I just had. Direct examination, go ahead.
So we were discussing November 19th of 2018, and it was your birthday. Later that night, did you celebrate your birthday?
Yes.
Okay. And then what's the next thing that happened after that?
Katie, Mr. Caneiro's daughter, called us at shortly after 5 in the morning to tell us that there was a fire at their house and we should get our dogs and get out of the house in case there was a chance of it jumping to our house.
Okay. And did you see the Caneiro family at all that morning?
I did not.
Okay, and what was the reason for that?
We couldn't get to them through the backyard because of all of the fire activity. And we couldn't get around on the street side because it was all blocked off.
And did Susan spend the night with you that night?
Yes.
And obviously a lot of time has passed since November of 2018. Are you still close with the Caneiro family?
Yes, very much.
Thank you.
Cross.
Thank you, Judge. Good morning, Ms. Gould.
Good morning.
Just a couple of questions. You indicated that you would see Mr. Caneiro and interact with his brother and Jennifer and the kids on occasions?
Yes.
And I think you indicated that those would be, or maybe you didn't, but what kinds of occasions would those be?
Christmas Eve always, and then if there was a birthday party for one of the girls, or a barbecue on the weekend, haphazardly, sometimes a holiday, sometimes just to have a barbecue.
Okay, so it was on rare occasions that you would see them interact.
Occasional.
And it would be during happy times, right?
Yes.
Vacations, barbecues, things like that.
Yes.
Yes.
Certainly, you didn't know how Keith Caneiro and the defendant interacted with one another when nobody was around, is that correct?
Correct.
You weren't privy to any of their private communications, right?
Private, no.
Or their interactions over the phone?
Personally, no.
No. You were not present for any of their discussions regarding business, right?
Not that I can recall,
Or
just
any of their disagreements?
casual conversations, but nothing.
You didn't know anything about any financial arrangements that they had, is that correct?
Correct.
You didn't know anything about the defendant's financial situation, is that right?
Yes.
He didn't confide in you about his finances or anything like that?
No.
And you didn't know about any escalating tensions between Keith and the defendant in 2018, did you?
Objection.
Go ahead, what's your objection?
She's characterizing it as escalating, and that's argumentative.
Okay, just ask it differently.
Sure. Did you know anything about any tensions between Keith and his brother Paul in 2018?
No.
You weren't aware of any arguments that they may or may not have had, is that right?
Nothing specific, no.
You weren't aware of any frustrations that Keith may have had with his brother Paul, is that correct?
Objection asked and answered as far as she's not aware of any of these private conversations.
I'm going to allow it. Go ahead.
I'm sorry, can you repeat?
Sure. You weren't aware of any frustrations that Keith may or may not have had with his brother Paul, is that correct?
Correct.
You weren't aware of any future plans that Keith may or may not have communicated to his brother Paul about their businesses, is that correct?
Yes. Correct.
Correct. And were you aware of any other financial situations with regard to the defendant being the trustee of an insurance policy?
I do not believe I was aware of that then.
Okay. And is it fair to say you were closer with Susan Caneiro than you were with Paul Caneiro?
We spent more time together, yes.
And in fact, you indicated you saw her on November 19th.
Yes.
You guys had tea together?
Yes.
All right. Did you see the defendant on that date?
I did not.
And certainly you did not see Keith on that date, is that right?
Correct.
And you weren't privy to any phone conversations that the two of them may have had or may not have had, is that correct?
Correct.
You weren't privy to who was angry, is that right?
Objection, again, just this has been established.
I'm going to sustain the objection to the form of that question. So you can ask it differently, but I think that question is improper. Go ahead.
Ma'am, were you aware of any communications that Keith and Paul had on the night of November 19th?
No, I was not.
So you were not aware of any ultimatums that Keith had given Paul that night?
Yeah, I'm going to sustain the objection. She doesn't know, so she doesn't know. We're going to leave it there.
You indicated that you were close to Susan Caneiro.
Yes.
Were you aware then that she and the defendant slept in separate bedrooms?
Yes.
Were you aware that Susan actually slept in the master bedroom?
Yes.
Were you aware that the master bedroom right beneath that is the origin of the fire?
Yes.
I have nothing further, Judge.
Okay. Any redirect?
The summer of 2018, how often would you see Paul and Susan and their families?
The summer of 18, probably 3 or 4 times a week.
Okay, and how often would you see Keith and Jennifer and their kids?
Over the course of that summer, maybe 3 times.
Okay, and you also, you mentioned holidays, right?
Mm-hmm. Yes.
Okay, and so you've known the Caneiro family for how long?
Since 1996, so 25 years at the time.
Okay, and obviously, you didn't see Keith and Jennifer and their family as often as you saw Paul and Susan's family, right?
Right.
Okay, but did you see them, like, regularly? How often?
A couple times a year, minimum. 3, maybe 4 times a year.
And that's over the course of 20-something years?
Yes.
And did you ever, even if you weren't present with them, were there occasions where you would just learn things generally, without saying what you learned, just learn things generally about the family?
I don't know what. Come on. Ladies and gentlemen, I'm going to sustain the objection to that question, but I'm going to allow a new question. Go ahead.
Ms. Gould, did you talk to Susan regularly?
When?
Just generally
Oh,
over the
yes.
course of all the many years you've known her?
Yes, absolutely.
And did you also talk to Paul regularly over the course of the many years you've known him?
Less frequently, but regularly, yes.
Regularly.
Yes.
And when you would talk to Susan and Paul, or maybe their children, was a topic of discussion often family?
Periodically, sure.
And there were obviously a lot of questions about what you don't know, right? Was your relationship with Paul and Susan and their family, was it, and Keith and Jennifer, was it more personal or was it business?
Personal.
Okay. And obviously you can only speak to what you know, right?
Yes.
Okay. Based on what you do know, did you ever have any concerns about the relationship between Paul and Keith?
Objection.
Sustained. Before that question.
I'll just ask you this one more time. Based on what you do know, how would you describe the closeness of Paul and Keith and their families?
They were very close. Paul loved Keith and Jen and those children.
Thank you.
You can step down, ma'am. Ladies and gentlemen, we're going to take our mid-morning break right now. Please don't discuss this case, do any research. We'll see you back at about 10:25 or so, depending on when you're ready. Thank you. All good? All good. All right, so everyone take the break. We'll see you back at 10:25. seated, thank you. Just took something to take care of the cough. No more coughing. You guys can yell if you want to cough again.
We're doing this.
All right, so we're back on the record, and we'll continue with the defense's case. The defense can call their next witness.
Judge, the defense is going to call Mr. Jim Pritchett.
Okay.
Just gonna walk around to the west.
Morning, sir. Just watch your step as you're coming up here. And then when you get over towards the witness stand, if you could just put your left hand on the Bible and raise your right hand for me. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can take your seat,
Thank you.
sir. And once you're comfortable, can you tell us your full name and spell your last name, please?
It's James Pritchett. That's P as in Peter, Ritchett.
Sir, I'm just going to ask you to do me one favor. When you speak, please make sure you speak loud enough so that jurors number 15 and 16 can hear you, okay?
I'll try.
Okay. If not, I'll keep an eye on you, all right?
Thank you.
I got you. All right. Ms. Mastellone, whenever you're ready.
Thank you. Good morning, Mr. Pritchett. Can you please introduce yourself to the jury?
Hi, good morning. I'm James Pritchett, but I go by Jim.
And are you currently working?
I'm retired now.
And what did you do before you retired?
Leading up to retirement, I was in B2B sales for an insurance company, and then before that, I ran a business for Morgan Stanley.
And even though you're retired, do you do any type of work currently?
I volunteer. I volunteer at a local community center. I chair a couple of committees and was on the board for a couple of years. I'm also a what's known as a CASA. It's a court-appointed special advocate for children in the New Jersey foster care system.
And what's your educational background?
I have an undergrad degree in psychology, and I have an MBA in finance and investments.
And who do you live with?
I live with my wife, Stacy.
Okay. I want to first talk to you about the Caneiro family. Do you know Paul Caneiro and his family?
Yes.
And other than Paul, who else is in his immediate family?
There's Sue, or Susan, his wife, and his daughters, Katie and Marissa.
And can you tell us a little bit about how you know them?
Yeah, I met them, I met the entire Caneiro family back in 1993. I started dating my wife, and she's very good friends with Susan. And so I started going to different functions that they were having, like different events. They had a barbecue, I think was the first time. And, you know, started hanging out with them over the summer on a pretty regular basis. And then at the end of, even at the end of '93, I was at their house for Christmas Eve.
Okay, and so 1993, approximately how many years is it that you've known them?
Probably it would be about 33 years, sometime in April or May.
Okay, so I want to talk to you a little bit about how well you know the Caneiro family. You kind of started to go into it, but how, can you explain to us how over time your relationship with Paul and his family developed?
Yeah, we spent a lot of time together. Stacy, my wife, was pretty good friends with Susan, if not best friends, and we would go and hang out with them. We lived in the city, they lived in New Jersey, so it was a good way to escape the city. And we just started talking about things, you know, we had common background, we didn't, you know, kind of blue collar growing up, and so, you know, I grew up in the Bronx. They were from Brooklyn and Staten Island, and we just started hitting it off. So as I started becoming more friendly, it meant that, you know, we were both going out and spending more time with them.
And what about your kids? Were your kids and close with the Caneiro kids?
Yeah, they're like family, you know. I've known Katie since she was, I don't know, 2 years old maybe. Marissa since the day she was born, and my girls have known them all of their lives. And given the amount of time that we spend with them, you know, it's a family thing, I suppose.
And over time, like, what are the different types of activities you could tell the jury that, you know, you and Paul and Susan and the girls and your family, what kind of activities and things would you do, kind of get-togethers, things of that nature?
Lots of barbecues over the summer, I guess, as soon as, you know, it starts off with kind of Katie's birthday, because she was end of April, all the way through the end of the summer, just being down, having barbecues. Sue and Paul seemed to always love to host, and we were happy to take advantage of that. You know, we were down there so much, probably should have been paying them a rental fee for being there in the summer. Beyond that, birthday parties for all of our kids. We went on vacations together. Went to Spain. Went to our first trip to Disney with our girls was a joint trip with the families. And Hershey Park is another one where, you know, we've gone multiple times with them. Even actually taking Katie and Marissa at times where Sue and Paul didn't go. So.
And you mentioned earlier that you were living in the city. At some point, did you move to New Jersey? And at some point, did you move to New Jersey?
We did. We moved after 9/11. We moved into town up in Union County.
Is this like 2001?
2001, yeah. Beginning of 2002, by the time we actually got to physically move in.
And once you moved to New Jersey, did you then see the Caneiro family like even more often?
Probably every other week, it seemed like, you know, and wasn't so much of an issue in terms of traveling and everything, especially for us back then. Being in the city made it a little bit harder to see them, but then we were able to just kind of jump on the parkway and see them a lot more.
And would you consider yourself and your family close with the Caneiro family?
Yeah, we kind of think of them as an extension of our family. I mean, we have spent so much time with them.
And like, how do you refer to Katie and Marissa?
They're like our nieces in a sense, and I think that, you know, our daughters and Katie and Marissa think of themselves almost as cousins because they've spent so much time together. So.
Okay. And so it sounds like you saw them fairly often.
Yes.
During the occasions that you would see them, whether it's a barbecue or a holiday, I'm not sure if you mentioned that. Did you spend Christmas with them?
Christmas Eve was kind of a tradition for us, I think, pretty much since 1993.
Did you know the Goulds?
Yes.
Okay. And so in light of the time that you've spent with the Caneiro family, whether it's barbecues, summers, weekends, holidays, did you have the occasion to also get to know Keith and Jennifer and their family?
Yes. When I first met Keith, it was actually at the Christmas Eve thing in '93, the get-together. And then eventually, once he and Jennifer started dating, I started seeing her more. And then, you know, when Jesse and Sophia were born, we saw them as well, because they were over a lot with them too.
Okay. And just just to kind of tie it all together, like what kind of events and holidays and get-togethers would you see Jennifer and Keith and the kids?
Well, they were there for the barbecues too. They were there for different birthday parties. We might have been at their houses for we had been at their houses for birthday parties for both Jesse and Sophia. They'd be over for Katie and Marissa's. So we would see them with that. You know, just basically every function that you could think of. I mean, it was kind of a close-knit circle, so, you know, we were always there.
Did you go to their wedding?
We did.
And so based on how well you knew the Caneiro family and how well you knew Paul, how would you describe Paul?
Paul's smart, level-headed, very loyal in a sense, and I guess giving. You know, he was always willing to lend a hand with different things, you know, either sharing an opinion or, hey, I need help doing something. He made himself available.
And how would you describe the relationship between Keith and Paul?
They were brothers, and they were really close. You know, I don't have a brother, but if I did, I would have loved to have had that type of relationship in terms of how close they were.
What about their bond? How would you describe their bond?
They were close, and it was kind of the Caneiro brothers against the world, whether it was just sitting there, you know, talking about something, you know, or having a discussion, or if they were, you know, in business, same sort of thing. Just, you know, them against the world. They were just really close and loyal to one another.
And what about Paul's relationship with Jesse and Sophia? What can you tell us about that?
I know Paul loved both of them. You know, like having grown up with daughters, you know, Sophia was just, you know, another beautiful little girl, and, you know, he loved Jesse. I thought that he was a calming influence on Jesse, and I don't know, it seemed like there was a special bond between the two of them, because he was really the only little boy out of the group, Paul and Susan having girls, myself having girls. He was the only kind of boy in the mix for a while, so.
Thank you. Now, focusing on a little bit of their business relationship, are you aware of the two businesses that Paul and Keith own together?
Yes.
And have you ever been to the business's location in Homedale?
Yes, I have.
And what about the one in Asbury?
Yes, I spent time there too.
And you mentioned you spent time there. Can you explain that?
Yeah, I had left Morgan Stanley in 2010. I was trying to figure out what I wanted to do next. And Keith and Paul had offered me office space, and while I kind of figured out what I was going to do there. And so I got to spend significant time at both the Homedale office and at the Asbury Park office.
And when you were there, did you have the occasion to interact with Paul and Keith?
Yeah, on a pretty regular basis, I did.
And so how would you describe their business relationship?
It was good. They worked together, they complemented one another in terms of their skill sets. You know, they kind of understood that, again, I guess I said this before, but it was them against the world. They were going to do what they needed to do to figure out how to make the business work best and to be able to succeed.
And how would you describe Paul and Paul's way of communicating?
Paul's always been a bit more measured, level, kind of direct. about it. He didn't, you know, he was more reserved, I suppose.
Was he more emotional versus logical?
No, he a lot more logical and even about things.
What about Keith's way of communicating with Paul?
Keith was animated in general. It was just kind of his style where, you know, he would challenge a certain notion or presumption. You know, if they were doing something with the business, he'd want to know, well, how, can you explain to me how this works or something? And, you know, but it was like almost throwing down a gauntlet for responses to problem solve. So
was his approach more logical or more emotional?
it was more emotional. I mean, again, they were a good compliment from a business perspective on there. Like, he needed to have things proven to him, and he was going to let you, there was no mystery about what Keith was actually thinking from that perspective. It wasn't a negative, it was just different from Paul.
So, and since you've had the occasion to see a lot of their communications when you were present, of course, did you have the occasion to see any disagreements between the two?
Yeah, I mean, yeah, excuse me, yes.
And how would you describe those disagreements?
I think that they were, I'd probably describe them as constructive conflict, because Keith would kind of put something out there and, you know, it would be in his animated sort of way with everything on his sleeve, and Paul would sit there and listen to Keith and go through it and then kind of explain, well, here's why these things work over there. So again, kind of a complementary way that they communicated, and, you know, once they figured out the issue, it was good. You know, I think it was just an interesting way. It's not as corporate, I would say. Like, having worked in the corporate world, every idea is great, even though it may not be, but, you know, every idea is great and everybody's opinion matters. But you don't have that same sort of thing in a smaller business, and I think that they were really effective in that sense.
Okay, and as far as their relationship as business partners, how would you describe their partnership?
They were partners, they were equals, I guess. You know, it was a 50-50 partnership in the sense of how they did the business. Paul might have been maybe a little bit more technical than Keith, but they were equals in the business, and that's the reason for a lot of the discussions that they had.
And to your knowledge, like, did one brother contribute more than the other? Because you're talking about equals, and notwithstanding ownership specifically, but more so just like in the way that they handled the business day to day and the activities.
Jack, calls for yours.
ask a different question. All right.
When you were at the, you said this was like around 2010, 2011 or so?
Yes.
And so when you were at the, and I think you mentioned you were renting office space or using office space?
I was using it, yeah.
Did you ever engage with Paul and Keith and discuss the businesses with them?
Yes.
And without saying like what was said, can you just talk generally about, just like the types of things that you guys would discuss with respect to the businesses?
I was getting ready to say typical, but discussions about whether or not how you finance certain things. Do you buy? Do you lease? How do you interface with the media on certain things for a business? What your approach would be to doing that. So like public relations type things. Just different issues where there's like two different viewpoints, but specifically, finance, marketing.
And so were you like sitting with them in the same
Yes.
room having discussions?
Yes.
And were they asking for your opinion? Were you consulting with them?
They asked me what I thought, given some of the experience I had out in the business world. Could be like, hey, is it better to just own something outright, or are we better off leasing and financing something, or, as I was saying before, the issue of how do you interface with the media on certain things without getting too into detail. There was an issue of bed bugs, and there were different interviews going on, as an example of something.
You were talking about the pest control business at
Yes.
that point? Okay. Now, so just based on like your observations during this time where you're watching the brothers communicate and watching them discuss the businesses, did it seem like they were taking like equal part in the conversation?
Yes, they did.
Okay. And based on what you were able to observe from the day-to-day while you were there, was it your impression that the brothers were working together? Was one brother doing more than the other, or were they doing
Judge,
it?
the same question from before, and I don't even know what time we're talking about.
And it's leading. So I'll allow you to ask a different question, but Mr. Decker is correct. Are we talking about 2010 and 11? I'm not really sure.
Right, during the time that you were there, at that time, and you were sitting with them and talking with them, the question is just, how did you observe them as business partners as far as being equals?
Well, when there were issues that needed to be resolved, they relied on one another. They sat down and talked about how they should approach something. So just in that sense, it appeared to me that they were equals because they didn't make a significant decision without consulting with the other.
And based on your understanding, like, what were the roles within the business?
Paul was, in my estimation, he would have been like a COO or something, understood how the business worked, what the administrative ends of the business were, as well as some of the technical stuff.
And I'm gonna fast forward a little bit.
Okay.
So when Keith went back to school, how did Paul handle that situation?
He was good with it. I mean, it meant that he was doing a little bit more of the day-to-day because Keith was in school with class, but he seemed to be fine with it. I think he was happy for his brother for Keith because it was important for Keith to go to school, and he was going to Columbia, and so there was a lot of prestige with that. And Keith felt good about himself doing it, so. And I think Paul felt good for Keith at that point.
And so was Paul supportive?
Absolutely.
Fast forwarding a little bit more, after 2018, do you know who took over the businesses?
Objection. Relevance.
Can I see the attorneys? 2018 is a pretty long amount of time. Ms. Massalone, when you're ready.
Mr. Pridgett, just a few more questions. So, I think the question we left off was, after November 20th of 2018, who took over Keith and Paul's businesses?
Corey Caneiro did.
And how do you, how soon after November 20th of 2018 did that happen?
Within days.
Thank you. Now, obviously, a lot of time has passed since 2018. Are you still close with the Caneiro family today?
I am.
Thank you.
Cross.
Thank you. Mr. Pritchett, how you doing?
Good, thank you.
Just wanted to ask you, those questions you were just asked, I mean, somebody had to take over the businesses, right? To make sure that people got paid and customers got serviced, correct?
Yes.
Correct. Am I right?
Yes.
Okay. Now, you talked about, a couple times, talk about how Keith and Paul were partners, right?
Yes.
They were partners in Square One, right?
Yes.
And also in EcoStar, right?
Yes.
And you also referenced, when you said partners, you said 50-50, right?
Yeah, in terms of being equals, I don't know if there was a partnership mix or anything like that. I just know that they behaved as equals.
Okay. They behaved as equals, correct? And are you saying you don't know who owned what with, let's just say, Square One in particular? Who owned what percentage?
No,
You don't know?
I don't.
Okay. And EcoStar, you don't know either?
No.
Now, you were talking about the Home Bell office, Square One, right? That was a while ago, right?
They were there in 2010.
Yeah, 2010, and then they moved to the Asbury Park office later, correct?
Yes.
Okay. So were you saying that you were using an office in just Asbury Park or in both?
Actually, in both.
Okay. What year did you retire?
Officially last year in 2025.
Now, you were asked some questions about Paul being very level-headed, right?
Yes.
You said that, right? And you said Keith was more emotional, right?
Yes.
Kind of always knew what he was thinking based upon the way he interacted, correct?
Yes.
You said something about like he wore his emotions on his sleeve, right?
Yes.
Okay, did you ever, or strike that, did you ever have the opportunity to view text messages or chats between Keith and Paul?
No.
Okay, you didn't read their messages, right?
No.
You didn't read the emails from Keith to Paul and Paul to Keith, right?
That's correct.
Okay. And you weren't privy to their phone calls, right?
No.
Each other?
No.
Okay, like you weren't overhearing Keith call Paul or Paul call Keith, right?
I might have, but nothing specific.
You described Mr. Caneiro, Paul Caneiro, as being loyal, correct?
Yes.
You also said at times he was always giving, right?
Yes.
Okay. Is it fair to say that you're not aware of any times that he was actually taking?
Objection.
I'm going to allow it.
I'm not sure I understand what you're asking.
Were you ever made aware of times when Paul Caneiro was taking financially from Keith Caneiro?
Objection.
I'm going to allow it.
No.
You said no?
I said no. I'm sorry.
Honestly, I just wasn't sure.
Somebody coughed. And it wasn't me this time.
Judge, I don't have any further questions. Thank you.
Any redirect?
Judge, can we approach?
Sure you can.
Pritchett, the prosecutor asked you, whether someone had to take over the businesses, right? But it didn't have to be Corey, right? It could have been someone else.
Yes, in all honesty, I was a little bit surprised.
Sir, that's the answer to the question. It's either yes or no. Somebody else could have taken it over?
Yes.
Okay. I'm going to strike the part after the word, yes, it could have been somebody else.
And to your knowledge, over the course of the, let's say, starting in the 2000s, from 2000 up until 2018, like those 18 years, did Corey have anything to do with the business?
No. Corey had been brought in a couple of times, I know, by Keith and Paul into the business, but it didn't really work out, and they wind up having to let him go from that.
And was this prior to 2000?
Probably late 90s and then maybe early 2000s. I tried to cut, there was a couple of instances.
Okay, thank you.
Anything else?
No, Judge, thank you.
All right, sir, you can step down. Thank you. We appreciate your time. Ms. Messalone, when you're ready.
Thank you, Judge. The defense is going to call Stacy Pritchett.
Ma'am, just watch your step. If there's a step up to the witness box, if you don't mind, please. Thank you. If you don't mind, before you sit down, could you put your left hand on the Bible, raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, once you're comfortable and seated, can you state your full name for the record and spell your last name, please?
Sure. My name is Stacy Pritchett. It's Pritchett.
Ma'am, I'm just going to ask you to speak up so jurors number 15 and 16 can hear you, okay?
Of course, yes.
All right, thank you so much. Ms. Messalone, when you're ready.
Thank you. Good morning, Ms. Pritchett.
Good morning.
Can you please introduce yourself to the jury?
Hi, my name is Stacy Pritchett. Should I spell it again?
No, you're good.
Okay. What's your current occupation?
I work in marketing.
And what's your educational background?
I have a BA in literature from SUNY Binghamton and an MBA in marketing from Brew College.
And are you married to Jim Pritchett, who we just heard from?
Yes, I am.
So obviously we just heard from your husband, so we already have some background. But can you just explain a little bit to the jury about how you met Susan and then Paul?
Absolutely. I met Susan when I was a sophomore in high school, so about 43 years ago. We went to high school together, we had a lot of classes, and we just became friends. We did a project together, and we just really hit it off. We were very close in high school. I went away to college, and I would write letters, and we kept in touch. And then after college, when I moved back home, we rekindled our friendship, and I would consider her my best friend, more like a sister, and Paul more like my brother-in-law. I've known him about 42 years, and I consider them like family. I consider Katie and Marissa like my nieces, and my kids introduce them as their cousins.
Okay, so just to back up for a moment, you mentioned you met Susan in high school,
I did,
right?
yes.
And you were around how old at that time?
I was about 15 years old when I met Sue.
And what about when you met Paul? How old were you then?
16 or 17, in that range. So about a year after I met Sue, I had met Paul.
So
They
still
had
in
started
high school?
dating, still in high school, yes.
And again, we heard from your husband, but can you just explain a little bit more about your relationship with the Caneiro family? I know you just explained that you consider them like family, but how did your relationship develop over the years with the families as far as like things you did together and events and activities and things of that nature?
We became like family. Sue, like I said, is more like my sister than my best friend, and Paul, my brother-in-law, the girls like my nieces. We went on family vacations. We went to Disney World. We went to Hershey Park like once a summer. We spent every Christmas Eve together. And during the summer, we were there like every other weekend. I used to joke that it was my shore house. But we spent a lot of time together as families.
And during the summer, we've heard a lot about these barbecues. Can you
Yes.
tell us a little bit about that?
So we would go, once they put in their pool, we were there regularly. We would go every other weekend. Paul is a fabulous cook. He would barbecue. He'd make the best steak that is still talked about in my house. And he would cook, and the kids would swim. We would all swim. They'd play on the trampoline. They'd play with each other. And we'd just hang out. We spent a lot of time with them in the summer.
So based on how well you knew Paul, how would you describe him?
I would say that Paul is highly intelligent, loyal, very helpful, dependable, very logical, and very even-tempered.
And did you say he was?
He's very helpful. He was always helpful to me personally, to us as a family. He was always there if I needed advice. He helped us with when personal computers became a thing. It was Paul who set us up. He set up my computer. He set up my mother's computer. Whenever I had an IT question or a technical question, I would ask Paul. He really was my go-to person for anything technical. He advised me on what tires to buy. And then when Jim and I moved to New Jersey and we bought our house, things were broken, and he came over with his drill. He fixed our cabinet. He fixed other things around the house. One time when my husband was traveling and my kids were very little, our boiler broke. And I called Sue and I spoke to Paul, and he told me what to do. I called a repair person, and then he stayed on the line with me the entire time that the repair person was there. So he was always very helpful.
And as a result of how well you knew Susan and Paul and their family, and how often you saw them, I think you said like every other weekend.
Yes.
A lot during the summer. Did you have the occasion to see Keith and Jennifer and their family?
Yes, we saw them every Christmas Eve because they would come every Christmas Eve, and we'd all exchange gifts, and we'd see them a lot during the summer. So they wanted to swim in the pool and eat Paul's cooking and play and hang out. So we spent a lot of time with Keith and Jen and the kids every summer, a lot of time.
And so based on what you were able to observe with the interactions with the family, can you tell us about Paul's relationship with Keith?
Yes. So in the 40 or so years that, approximate 40 years that I knew Keith and Paul, I observed them often, and they had a very loving relationship. Paul loved Keith very much. He would call him his person, his best friend. He was always there for Keith. He was they were best friends and business partners, and he was very protective of Keith, and he loved him very much.
And did you ever have the opportunity to see them disagree or argue?
Yes, I mean, they were brothers, so of course they disagreed. Yes, they would disagree. They would discuss things, get their feelings out there. I actually admired their relationship because they could disagree and then go back to being best friends, going to lunch. So they would disagree. Usually it was Keith who would lose his temper. Paul was always the more even one, the fixer, keeping calm. And they would disagree, and then they would resolve it. and move on and go out to lunch and just resume the relationship like nothing ever happened.
And what about Paul's relationship with Jesse and Sophia? What can you tell us about that?
I can tell you that he loved them very, very much. I would say that Jesse was the son he didn't have. He loved Jesse, he loved Sophia. He absolutely adored those kids. I know when Jesse was in preschool or kindergarten, he was allowed to bring an adult to school with him, and he chose his Uncle Paul. I mean, that was how much Jesse loved Paul, and it was absolutely reciprocated. He absolutely loved Jesse. He absolutely loved Sophia. He loved those kids.
Focusing on the businesses for a moment. To your knowledge, again, just based on your experience knowing them and what your personal observations were, and getting to know Paul, getting to know Keith over the 40-something years, were you privy to when the businesses started and as they progressed and things of that nature?
I was privy to some of it, absolutely. I know Keith started the business and then he brought Paul on, and Paul was the one who really grew the business. He went out and he got clients. He was very instrumental in building the business. I know they worked very well together. They were very compatible. I think Keith was more strategic and Paul was more like tactical, more hands-on. He was always there building the business, and they worked very, very well together.
Now, obviously, again, a lot of time has passed since November of 2018. Are you still close with the Caneiro family?
Absolutely. They are our family, and they always will be.
Thank you.
Ross?
Thank you. Good morning, man.
Good morning.
You said Keith would always lose his temper.
Not always. He was the first one to usually get agitated and start yelling.
Okay. Paul was very level-headed, right?
Yes.
Now, I assume you'll agree with me that you didn't hear Keith lose his temper on a phone call with Paul on November 19th, 2018.
No, I did not.
Never heard that, correct?
No, I did not.
You also said that Keith started the business, right?
Correct.
And you said that Paul then had a lot to do with growing the business, right?
Yes.
And I'm sure that's fair. But were you aware of the ownership structure of, when I say the business, let's say Square One, did you know who owned what?
I had an idea.
And what was the idea?
I think, mostly Keith's, and Paul was part of it as well. The majority was Keith's.
I have nothing further, Judge.
Anything else?
No, thank you.
You can step down, ma'am. Thank you.
Thank you.
Friends, call our next witness.
Judge, that's all we have for today.
Okay. All right. Ladies and gentlemen, you get to go home. So that'll end us for today. We'll be back again here on Monday morning, first thing, just like we are. I'll have you here at 8 o'clock. We'll have you up by 8:30. We'll continue on. There's things that the attorneys and myself have to do outside of your presence, so we'll be doing that. So it's not like the case is not doing something during this time frame, but I'm going to send you guys home. So I hope you have a great weekend. I hope it doesn't snow. And don't discuss this case and don't do any research. Thank you so much. Appreciate it. Ladies and gentlemen, so that the record is clear, what our plan is that the attorneys and the court, we're going to go through all of the exhibits after lunch to discuss what items that are allowed in or not, so that you're aware, just because something has been marked as an exhibit doesn't mean that the jury necessarily gets it. We wait until the court makes a determination whether it's going to be allowed in, so that's what's going to happen this afternoon, and we're also going to go over the jury charge again in anticipation of summations next week at some point. So with that being said, that'll be at 1:30. It's an open courtroom. If you want to be here, you can be here. If not, there will be no testimony this afternoon. It will just be going through the physical evidence and also going through the jury charge. All right? Just want everybody to know that. All right, I'll see everyone back here at 1:30.
Nah, just for the record. Yeah.
Superior Court is back in session. The Honorable Judge Mark Lemieux presiding.
All right, we're outside the presence of the jury. We're back on the record with State of New Jersey versus Paul Caneiro. It's indictment 19-02-0283. We have all the attorneys present. We also have the defendant present. I had asked the attorneys to go through the exhibit list for both the state and for the defense to at least be in a position so that you can tell the court what objections there are. We will argue those objections now, and then what we'll do is, after the defense rests, whenever that may be, at that point in time, I will formally move in the evidence. So it can be considered by the jury. So let's start from the beginning. At the top, from the prosecutor's office. I'm not sure who's going to be handling this, but let's start with the photo book. Tell me where we are. Tell me the ones that we are moving without objection, and if we're not moving them, the process that you're going to go about so that the record is clear. I see Ms. Wallace standing up. So the process of what you're going to, how you're going to go about blocking out pictures that you did not use so that we don't have any issues in front of the jury.
Thank you, Judge. We'll be moving S1, A through I. However, there are several pictures that we did not use that we would black out that I have listed.
Okay. I mean, have you gone through with the defense? Are both of you in agreement as to which photos are in and which photos are going to be blacked out?
I don't know that we went through those. I'm sorry.
This is, what have we been doing?
So Judge, if I could, before we broke for lunch, my understanding is that the court wanted the parties to organize their evidence and decide what each party wanted to move into evidence. So that's how the defense spent the lunch break. We went through all of our photos, we organized them so they'd be in order for the court and for the state to review so that they would be organized. We looked at our documented exhibits that we had. We decided, yes, we want things in or what have you. So that took the hour and a half or however long we had during the lunch break. Then when we came to court at 1:30, we were under the impression that at that time you wanted us to confer. So we had a copy of the state's updated exhibit list, but we didn't have access to their exhibits. So we weren't, it was kind of out of context, like an email dated. We needed to actually be able to compare from the item in the exhibit list to what the item actually is as far as whether or not we had an objection. So we just spent the last hour and a half. Once the court gave us access to those exhibits, we were able to categorize these items as far as either no objection or we do have an objection or we're reserving because we're just not sure. I think some of this has to maybe even be researched as to whether or not it's admissible. So that's where we are. We can let the court know certainly what things on their exhibit list we do not have objections to, or that we do have objections to, or that we are uncertain of at this time, but we can certainly let the court know and the state know early next week. Also, we did not have an opportunity to look at the photo book and see. I mean, I can represent that generally speaking, we don't have an objection, but perhaps once the state has the opportunity to black out the photos and has the final photo book that they're gonna present to the jury, we can just flip through it and let the court know if there's one or two photos that we have an objection to.
All right. So I'm not sure how the miscommunication happened because I had indicated that I wanted you guys not only look through your stuff, but also to discuss what objections that there would be. That's fine. We're here and we are where we are. So obviously, let me just say this. The items that have been testified to, that have been on that screen, there was no objection for those items to be placed on the screen. So I would have difficulty so the defense is aware, to not allow in photographs that the jurors have already seen. Foundations have been laid. Any photo that has not been shown is automatically out. So that's not even going to be an issue. And the way that I would suggest doing that is, how many are we going to do on a page for purposes of the jury book for the jurors?
For the jurors, it's going to be one per page.
So one per page. So if you're going to do that, then my suggestion would be is that you can just do them in chronological order. Just take out the ones that were never shown to anyone. I have my book also. I tried to write down that like everyone has here, which I thought was great. Good job. But I did the exact same thing to make sure that I have my own notes as to what picture was showed to whom. So I'll have that. So once you have that book, if you want to, over the weekend, I want you guys to talk over the weekend and look at the photo book, show it to each other. If there's any issues, that Monday when you come back, that we don't have to spend time, that it's just for you to take a look at it. And at that point in time, let me know if some picture you're saying was not shown to a particular witness, so you would have an objection to it, or if every picture was shown, you're going to have to prove to me why that now, after it's already been published, it's already been shown by a witness and its foundations have been laid, that I wouldn't allow that to be in. So I say that to you just as a background, so you know, for purposes of pictures I'm only talking about right now, that's it. That would be the court's request, that's going to be my ask of you. So you guys could take that advisement and instruction, and we'll talk about that on Monday. I won't touch the book for now. I recognize there's a lot of pictures, but a lot of this stuff I think should be pretty straightforward once you've had the opportunity to look at it. All right, so let's put that aside as to S1. Okay. What's your next item that you're attempting to move?
S2, Judge.
Okay. Was there any objection to that? I was shown today. Okay, so that will be in evidence. Next.
S7.
No objection.
Next.
S8.
No objection.
Okay.
No objection.
Okay.
S11.
No objection.
Okay.
S12.
No objection.
Okay.
S12 included some sub-numbers.
Yeah, 1.1.2.3, people marking it up. Any objections to the marked up photos, Ms. Mastalone?
I don't believe so, Judge.
You should have copies of those. I'm assuming Anna gave everyone, you have it? Okay, good. So for the record purposes, when I accept these, it would be not just S12, but S12.1, .2, .3, .4, and .5 will all be in. Okay, next. 17, I'm sorry? Okay, yeah.
No objection.
All right.
S18.
No objection.
S19, A, B, and C.
No objection.
All three, okay.
S26. Judge, I skipped one. S25.
That we do have an objection to.
The actual report?
Yes.
Why would you move the report in?
Judge, we won't, he can withdraw that. We won't move
Okay.
the report in.
Yeah, that's not in evidence. His testimony is what's, I will allow, not the expert report. 26 was next?
Yes, S26.
Okay,
I'm sorry.
No objection.
okay,
S28.
No objection.
okay.
And then S29.1 through 10.
Okay. I think I understand better.
Yeah, we had a question mark on that, Judge. If we could, it looks like it's a lot of the point exhibits, if we could just maybe,
Yeah, those are the ones that she either wrote on or there's circles on. That would be what was printed out here. She testified to it, and then we mark them that way, so that's what we're talking about.
Okay, so the S-29 itself is not coming in?
Yeah, S-29 would be the bank statements 3837 from
So
2017.
the full year of statements then? I mean, the thing is, if that's the way this is gonna go, I think it's important just to note that there were, not the entirety of those bank records was testified to.
I agree.
In fact, Detective Bassender said she specifically didn't review or didn't document certain areas.
I agree with you.
And if the state wanted to put in the full record, I would just note that, well, one, I think it would have to be heavily redacted, but two, it may prompt us to respond to certain, requests of the court to introduce certain items that we hadn't previously contemplated, but that were discussed with the witnesses. So I don't know how the court would want to handle that. I think just at the outset, we would probably raise an objection to the entirety of the statement.
Okay, but you don't have an objection to 1 through 10, because obviously something was circled on them or something happened with those,
They were
correct?
marked, they were shown to the jury, I think that's a different issue. They were essentially used in the presentation, so I don't think we have a basis to object on that.
I respect what you're saying. Ms. Wallace, my issue is, and tell me what the testimony is, and I'll take a look at it, but I don't recall the entirety of that exhibit being shown. And there may be other things in that packet that may have an issue to it, or some hearsay information in it, or something else that I'm not aware of. I don't know, I don't have it in front of me. But is it that you need 1 through 10, or do you need the entire document?
Well, these documents, so 3837, 2017, and 18, these were the bank statements that Detective Bassender relied on to write her summary charts.
Okay.
These are all of the defendants. I showed them to her, we marked them, and even though we went through them and she circled the areas where there were withdrawals being made from, well, I guess it would be incoming money from the trust account into those accounts, I highlighted different areas where perhaps his balance was negative or whatnot. We didn't circle those, but we talked about those areas. So I had provided her the whole document. I wasn't planning on moving like certain other bank records in, but these were pertinent ones for 2017 and 18. They were the defendant's main bank account.
Here's what I'm going to say to you. Why don't you take a look at the document, speak to Mr. Murray about it. If there are certain areas that were testified to, I will consider that. But always remember that the testimony is still there. It's in evidence. So it's still fair comment. And you do have these ones that you marked. So take a look at that over the weekend, discuss it between the two of you. If you come up with an agreement, fine. If not, I tend to agree with Mr. Murray on this, that I don't know if the entire document should be coming in. So let's just take a look at it.
Sure, we'll do.
Okay, so we'll come back to it. But point 1 through point 10, I have no issue with.
And then I think we have S30.
And you have point 1 through.
Yeah, it's a 2018 one, so I guess the same issue.
Same issue. So I have no problems with point 1 through point 19. Mr. Murray, I assume you don't on those. It's just the entire document again, right?
That would be right, Judge.
Okay, so let's take a look at that. Okay, next.
Next one that we had, I think there would probably be the same issues with these, because these are the bank accounts, S33 and S34, S35 and S36. Those are the remaining bank accounts that we looked at of the defendants, but I think there were points marked, so like S33.1, 34.1. So I think it's probably the same issue.
Yeah, so I have no problems with the point 1s, because we know for a fact that they were testified to, there was markings on them, so that testimony is noted, but the full records you guys got to take a look at, and you and Mr. Murray can tell me on Monday where you want to go with that.
Sure. And then S37 and S38, they were discussed, they were the TD Trust Bank account statements. I don't think we marked anything on them though.
No. So same thing, the testimony's there. I'm not sure that I would let it all in, because I'm not sure it's all in there, but you guys can take a look at it over the weekend, and we'll revisit 36, 37, 38.
Okay.
So actually, it'd be 33 through 38 that we will revisit, including going back number 29 and 30, we'll revisit. You guys can let me know.
Okay, will do. And then we've marked S39, but that's an expert report, and it sounds like we're not moving those, so. S40 would be, actually, report, just A and B, so that would be the charts that we use, the summary charts of the poster boards.
Yeah, so no, when we looked at S40, just so the court's aware, when we looked at the actual S40 exhibit, it did contain a portion of the detective's report, separate and apart from the charts. We don't have any objection if it's just the charts.
Okay. I agree, there's no issues with the charts, they should come in. But I'll just ask you to redact a portion of the actual report. Obviously, she testified to her report, so that's fair game for a summation.
And then S42.
Any issue with that?
Well, I mean, I think that we just had a question about in the state, they can, I don't know if this is their perspective on it or not, but, for example, as far as S44 and 45, the annual policy statements, like, we don't have any problem with documents like that coming in. They were testified to, they're fairly straightforward, they show the policy is active in those years, they show that where the records are going, they show who the insured is, right? So we don't have any issue with that, but the whole life policy of Keith Caneiro, that 19-page document, I don't know if the entirety of that was really the subject of the exam.
There's a lot of areas that were referred to both on direct and cross.
There were. And
should we give it to them for full context, so it's understandable, or what are you proposing?
Well, I certainly don't have an issue if it is, I'm not saying that anything that was discussed obviously can be brought up on summation, during summation.
Yeah.
And I would just say this, I guess our stronger, to the extent we have an objection here, our stronger objection is really S43. So, I guess what we could say.
Can we just reserve,
Yeah.
Judge, and talk about it? Can we meet and confer? Because this was in our category of like, we're unsure.
42 and 43?
Yeah.
Yes.
But you're okay with 44 and 45?
Yes.
All right. So 44 and 45 are good to go. 42 and 43, why don't you take a look at? Ms. Wallace, you can let me know also, because I definitely recall there was a lot of areas that were being referred to back and forth. So there may be something that you guys can agree to as to the areas that were testified to, because you read them into the record, so just let me know.
I think we're at S44.
Well, 44 and 45 were good. There's no issue, but Mr. Murray said there was no issue there.
S46.
No objection.
Okay, no objection there.
S47.
No objection.
S48.
No objection.
S49.
No objection.
S50.
No objection.
S51.
No objection.
S52.
No objection.
S53.
No objection.
S62.
I need to go back for a second. The S52. I'm going to go to the trusted paralegals over in the corner. Are we sure that
Oh, I'm sorry.
we didn't? I don't think that was shown.
Okay, then That was highlighted, I inadvertently then read it. If it wasn't shown, then.
Okay, so then 52 is not going in.
Okay.
I'll look back through my notes and see if I find it, but I'm sure that they have it. I'm not seeing it, so we'll just take another look. Both sides take a look.
It's in the Canada Life payment history, which was an exhibit that is going to be in evidence.
Oh, I do have it. On January 13th, it was marked. So we're okay. January 13th. So it's two, so that'll be in evidence. 52 is okay.
We have S53.
I think there was no objection to that already. Am I correct, Ms. Messalon?
We don't believe so. We think that was the history of the invoices on policy.
That's exactly what it is. Yeah. So no issue there, right?
No objection.
No.
Okay. Next.
S61 is just A and D, which would be the photos of the defendant's phone from Detective Nicolisi's report, and then photos of the Wise cameras from his report.
Yeah.
No objection.
Okay.
S62.
So we do have an objection to S62 through S65. These are the text messages or these are the text messages that Detective Miglorisi read into the record. They were shown on the screen, and then he would indicate like what each message stated. The problem is if the court may recall that like there's the messages themselves are not dated or time-stamped, and the state had printed each message individually on a page and stacked it together. We have concerns that it's not like a normal extraction report where it's organized and you can follow along. So we have concerns that if it's in the hands of the jury, it could easily get like disorganized and there's no way to put it back together. And also, I think that the testimony was sufficient, and I think if they wanted to know, if they had any concerns about it, they could also always either recall the testimony or ask for a readback. I have concerns about the formatting of those specific messages. It's just like a blank piece of paper with words on it. It doesn't say who it's from, it doesn't say who it's to, it doesn't say, or maybe it doesn't have the date or the time. It's not like in a pre-organized fashion.
Can I see those on the screen?
Some of them might have had who it was to, maybe, but not all of them, I think. And then the other issue, Judge, is we would also just maintain that objection to the first couple messages that dealt with divorce and not knowing where he was going to live. That was in April of 2018, not November. So, we would say that it's irrelevant, or object to relevance and prejudicial.
Okay. So this first one was from Keith, and it was testified to here that this is Keith forwarding to Corey.
Right, it doesn't say that though on this.
There was testimony.
Yeah, there was testimony that said who it was to. Okay, let me see the next one. Same thing, and it says from Keith Caneiro. It was testified to that it was to Corey Caneiro. Next. Same thing, it says from Keith Caneiro, and it was testified to Corey. Same thing for the next one, that's the fourth page. And the same thing with the last one from Keith, that was testified to Corey. So that's 62. So these are the text messages.
I think these are emails.
These are, they were in that the Google Hangouts section, so they're a mixture, I think, of emails and texts. And I would just note there's 4 batches.
We'll just call them messages. Yeah, sorry.
That's okay, there's 4 batches of them, and we put on the record each time he would testify to a batch. It was April 11th, September 13th, September 17th, and then the final ones are from 11/5/18. And Judge, I would just note they all do say who they're from.
Right. Okay. Let me see 63. For a minute. So the first one just says, did you talk to the Terminex people? And then the next one says, was testified that that's Paul's phone number. Yes, they're not budging. So your position with this, number one, even though it's documented, Ms. Messalone, even though that it's documented on the exhibit list, it's not noted anywhere on the exhibit as to the date when this happened, even though that I'm assuming the extraction report says that, but it's not attached to this. Is that a part of the argument?
There is no extraction report that is associated with these messages. They're not taken from a cell phone, they're taken from the Google Cloud, so that's exactly the issue is if they were associated with an extraction report, I would feel more comfortable with the jurors having organized information. If they were to drop the messages on the floor, they can't, there's no way to put them back together, they're not dated, they're not time-stamped. I think that it would be prejudicial to have them handling this type of uninformed information. I think they heard the evidence, and I also think it's pretty. These messages were subject to the to the pretrial litigation motion. So I think that there is an aspect that these are a certain level of prejudicial. Perhaps the relevant or was outweighed the prejudicial value, which is why the court ruled it. And it was admitted at trial. It was read out loud to the jury. I think it was
I got you. I heard you. I was just asking a specific question. All right, I'm gonna reserve. I'm gonna look at these.
Can I just supplement too?
Yeah, of course.
There is an index that was provided. I understand that the argument is that the jury doesn't have them, but there is an index where it has all of the dates listed. The defense sat with us over the summer time, and Detective McVerisi downloaded this onto their computer. They were able to view it. So there are dates. It's not that there aren't. It's just, I understand the argument that there's not necessarily dates on the page, but they were testified to.
No, I get it. The issue is that it's been testified to for these dates, but there's nothing if they go back and just take the document, there's nothing that puts the September 13th date on it, other than the testimony. So let me just think about it. But I understand the objections, and I will render that decision on Monday.
Okay.
So that's 62 to 65.
66 would be next, A and B.
no objection.
S69. Or it would be A through D, and then there's a D.1.
No objection.
All right, so it was 69, sorry, you guys went a little quick. 70, you said?
Yes.
And then 74?
Yes, and that would be A through D, and then on 74, there's also the D.1.
Point one. Right, and there's no objection to that one. Okay, next.
S76, A through D.
No objection.
Okay. Then,
S78,
No objection.
S93,
No objection.
okay.
S94,
No objection.
S96, that would be B.
We don't have an objection to B. What we wanted to do was, I'm not sure if maybe the entirety of both clips should be admitted, and for context, I'm assuming they were both played.
I don't think did we play the choruses?
No, one of the calls didn't play. They said 911 was the emergency and nothing. We didn't play it.
Okay, no objection.
All right, so it's just 96B,
Yes.
correct?
Yes.
Okay.
S99,
No objection.
S101,
No objection.
and then S102 and 102.1.
No objection.
S138,
Judge, we wanted to take a look at that more. We're uncertain about that. If we could just reserve on that for the moment.
You want to put in the evidence property receipt?
I think, yeah, I think it was just for purposes of chain of custody to document, but
Can I see 138? I think I can answer this. Ms. Massalone or Mr. Murray, is there an issue that you are going to argue as it relates to contamination of the evidence of those 4 items?
No.
No.
Okay, so if the answer to that is no, then I'm not going to allow it in. It's not necessary.
okay,
If there was an issue with it
sure.
on another evidence property receipt,
Okay.
then I would consider it for them. But if they're not, I'm not going to put it in for any other reason, okay?
Sure. S150.
It can be talked about in your summation, but it just can't. All right?
S155,
No objection.
S156,
No objection.
S157,
No objection.
S158,
No objection.
159,
No objection.
160,
No objection.
161,
No objection.
162,
No objection.
163,
No objection.
164,
No objection.
165,
No objection.
166,
No objection.
168,
No objection.
169,
No objection.
170,
No objection.
171,
No objection.
172,
No objection.
173,
No objection.
74,
That we do have an objection to based on relevance. And same with 75 as well.
Go ahead, Ms. Wallace.
Thank you, Judge. I would just note, these were shown to the jury, the relevance of the savings bonds. I mean, I think it's something that he had, and what the state's position is his go bag, essentially, along with his passport and some of the other items that were listed in there. S-175, the mail that identifies him as being his backpack, the financial documents in there, et cetera. I think that those are relevant as well.
I understand that the objection by the defense. I do find these to be relevant, and I also find under the circumstances that under a 403 analysis, I do find that the probative value outweighs any prejudicial effect. The theory of the state in this case is that the defendant, after he allegedly committed these offenses, that he was going to take off and he was going to need money to get out of here. was so included all of the information, all the items that were in this bag, to include savings bonds, and to show identification of the bag, 175, I do find to be relevant. Again, under 403, I do find that the probative value outweighs any prejudicial effect. Even if there is some prejudice, it's not enough to overcome it. So I'm going to allow in 174 and 175.
Just so, as far as like identifying the bag, 172 with his bank card and things of that nature, his passport, obviously that makes sense. The concern with is also like the hearsay of the mail. I don't know what mail this is. I have no idea who it's from, who it's to. I don't know, is it open? Is it, like, what's the mail? Why does that?
It's in a bag that's actually secured and fastened, so I don't expect anyone to be going through the mail or manipulating a piece, but go ahead.
No, it's just for the idea that he had all this stuff in the bag. We're not gonna go and rip out, they're not gonna be opening.
And I'm going to tell them that they can't do that, Ms. Massalone, so I understand your objection. It's definitely noted, but I disagree for this one.
Next one would be S-176.
No objection.
S-177. S-178.
So I think this, if we could reserve, I think one of our objections is just, a lot of the firearms were shown to the jury. I understand the court made a ruling with respect to the weapons cache and how it's relevant, but any firearm that wasn't used or alleged to be used in this case, I don't know if that might confuse the issues, if we're admitting all of these guns into evidence, and firearm. So it was something that Mr. Murray and I wanted to confer about further, because we were just, so maybe that's something we can reserve on.
Tell me what 178 is again? I'm reading it, but just remind me of what it was.
So Judge, what it is that the gun was found in a case. It's a locked case under the defendant's wife's bed. It's a black case.
Oh, the one, we saw a picture of it.
Everything was kept in the case except for the gun, because the gun was submitted to the lab. The gun is actually in it's in a gun box. It's one of the gun boxes that was shown to Lieutenant Catalona. And this case has everything else. It's got a knife, it's got a magazine, got a box of 9mm cartridges.
Tell me how this one is relevant underneath the bed, that that it would be necessary for the jury to have it.
Well, I mean, he's got guns in that bedroom, he's got guns in the bedroom that's his own.
I'm not disagreeing, he didn't have guns all over his house. What I'm saying is, I'm asking you just so the record is clear, why?
Yeah, Judge, obviously, he's got access to guns that are in more than one place in this house. One's in a gun locker, the gun safe didn't have any guns in it. He's got one in the bedroom, in his bedroom in the drawer, with the laser sight in it, and then he's got this one underneath his wife's bed. I mean, obviously, it's been testified to, it's been ruled admissible by the court previously, so I'm not sure I understand the objection.
Okay, all right. I'll give Ms. Massalone the weekend to take a look at it, if there's something she wants to submit on this particular one. I did rule on this as a pretrial issue, that I was going to allow this to come in for this limited purpose, which is located in the jury charge, but we can give Ms. Massalone the weekend to take a look at it. Next.
S-179, that was actually the gun that was in that case, so I don't know if it's the same issue that Mr. Decker just talked about. It was
The actual gun.
Yes.
Is there there's no objection to that, is there? Or is there objection to that one too?
The actual gun that belongs in the case, or?
The gun was found in the case. The only reason it's not in the case now
You
is
sent
because
it out to the lab, right?
Right, so it's not the gun, like the gun that's alleged to have been
Right.
used.
Correct.
So I think our objection is really just, again, the purpose of the weapon cache, I think, has been sufficiently established, and the jury had the opportunity to not only hear the testimony about all the weapons, in and around Mr. Canero's home, which obviously it's out there, we're not, you know, it is what it is. And on top of that, they got to actually see numerous weapons from the witness stand. So the objection is really just as to the prejudicial nature of them having the physical guns. I mean, it's one thing to hear testimony, it's another thing to hear facts and to see them. It's another thing to have access. Like, if they wanted to see the guns, they can just, you know, see them all. I mean, it seems...
Well, they actually can't see any of them because none of them are allowed back in the room. They're just in evidence, so to speak, but they will never leave the state's possession unless for some reason they wanted to see it. If they wanted to see the cache of guns, they would have to come out here. We would have to all be a part of it, including Mr. Caneiro. And I would, if they did ask that, I'm telling everybody straight, is that I would remind them of what they could use that for and what they couldn't use it for. So it's really more of like, it's an exercise, and we're saying that it's an evidence, but it's really not going in there for them to have any.
Of course, Judge, I obviously understand that, but that's what I meant. I meant, like, if they wanted to see the guns, they could see them, right? And why do they need to see them again? I don't think that, I think it would be prejudicial for the jury to have, when I say access to them, I don't mean that they're stacked in there with them. I mean, like, if they wanted to see them again, I think the point of the weapon cache has been established. I think the means and opportunity that the state wanted to establish has been established. And just the idea of the jury being able to say, we want to see those guns again, we want to see all of them, we want to look at them, we want to examine them or see them in the courtroom. You know, that's, at that point, I think we're going astray of what, you know, the evidence in this, what the relevant evidence in this case truly is.
Okay. But is this something that you wanted to reserve on, or do you want me to rule right now?
If Your Honor wants to rule now, that's fine. I mean, that's our position.
Okay, and I respect your position. Under the circumstances, because we're giving that limiting instruction, I have, while I understand the argument, I respect the argument by the defense, I don't have the same concerns. The reason why that I would find that this to be relevant is if for some reason the jury is trying to understand the defendant's ability to understand how to use guns, even though there's testimony about it, if there was something about some of the other weapons that to show more familiarity for one of the jurors, I have no problem with them being able to see them. They're not going to be allowed to touch them or anything else, and it would be, like I said, it would be an open court. So I'm going to allow S-179. I will stay reserved, though, on 178, on whether that's necessary or not. But for 179, I do not have a problem with it based upon what I've said in the previous ruling and what I said here today. And just so that it's clear, on this final exhibit list, that was shown on January 22nd also. Okay.
Computer glitch that day.
That's okay. It's okay. Next one.
S-180.
No objection.
S-181.
So anything that was like another firearm, it's just the same objection. So.
And they're all noted for the record, and my reason is the same for each one of those. So, but I get your objection, and it is noted for any firearm other than the alleged firearm used in this case. There will be a standing objection for the defense. I respect that. I'm overruling that objection. I'm going to allow them. Go ahead.
S-182.
No objection.
S-183.
So just to clarify, I mean, so, sorry. I guess like
182 doesn't need to go in.
180.
Judge, I'm sorry, just for purpose of clarification, we can leave S-182 out, that's just the box. S-183 is the actual target. That's my fault for not identifying that.
Okay, so it's just 183 you're looking for.
Yes, I think that's really the evidence.
Are we on 183?
Yeah.
Okay, no objection.
Okay, next.
S-184,
No objection.
S-185,
No objection.
S-186,
No objection.
S-187,
187 and 188 are just the same.
Same objection and noted for the record, but they will be in evidence. Go ahead.
S-189,
189 through. Okay, so just to speed it up, 189 through 192, same objection.
All right, they'll all be in evidence.
S-193,
S-193 is the gun, so that's the alleged gun. No objection to that.
Okay.
S-194,
No objection.
S-195,
No objection.
S-196,
No objection. No objection.
S-222,
Same objection, small plastic bin with 6 magazines and 11 unfinished lowers. Same objection, just.
Tell me about this one, Ms. Wallace or Mr. Decker.
Yeah, Judge, I believe, I have to look at it, but I don't even know that we even opened this up. I obviously, as the court can see and as the court knows, if you go forward and back, there was a lot of items that I chose not to actually identify and not to actually display, including the rifles and the Uzis and the, thousands of ammunition. I used the one as a sample. I think this was another one that was just to represent as an example, but I can look at that in our vault downstairs just to.
Take a look at it, let us know if that's an issue. If there is an issue, if you do still want to move it, just let the defense know and then we can argue that. So I'm going to reserve on that one for now. Next.
S-225,
So S-225 and S-226, we had an objection to relevance and prejudicial. It's, the bulletproof vest, I believe, was shown to the jury, but it's just, there's no relevance here. It's not alleged to have been used. It's just in the basement, something that was found. And similarly, the bin with old spare cell phones, there's no I don't know what the relevance is. So I would object.
I hear you.
Judge, the relevance on 226 is the old phones. There was discussion about how the defendant left his phone home, and so the FLIR, only works in a phone. But there are these spare phones that were found.
There's no evidence to support that they were actually used. Is there? That these cell phones were actually used by the...
No, I was going to say not specifically, but I mean, that was an argument that his phone was home. There are all these other spare phones.
Okay. I'm not going to allow either one of those in. That you guys can argue that, but I don't find that they need the physical items of the vest and or the cell phone, so I'm not going to allow them physically into evidence.
The next one, Judge, is S-230.
No objection.
And then S-231, it would be A through E.
No objection.
S-232.
No objection.
And then S-233.
No objection.
234. 235. 236.
No objection.
237. 238. 239. 240.
No objection.
And 241.
No objection.
242.
No objection.
And I don't think we showed 243, so not 243. The next one is S-253. No,
Are you doing 244?
254, are we not? I'm sorry, Judge.
Did you say 244?
We marked it on our thing.
I don't have 244 as being shown.
And I guess the next one, I'm sorry, not 253, it would be S-256. No.
No objection.
Okay.
S261, and then there's a 261.1.
No objection.
S262, and there's also a 262.1.
No objection.
S263, all of the A through, it looks like M, and then 263, B through M.
No objection.
So all of that is in. Okay.
S264,
No.
S270 and 270.1,
No objection.
S271A through F, and then 271A.1 and 271C.1.
No objection.
Those are all.
S347. Just trying to go down the line, I'm sorry. Yes, S375.
Wait, I'm sorry, what?
S375. The rest, I think they were all either reports
Property
or...
receipts or lab reports or whatever, yeah.
375?
Yeah.
No objection.
S391. S392, it would be A, E, and H were the ones that were played.
No objection.
So just those three.
Yes, those are the only ones played. Next one would be S405,
No objection.
407,
No objection.
S418,
No objection.
419,
No objection.
S437, thank you, 467,
No objection.
S474,
We weren't sure what that is. Is that?
timeline that we have. That was the timeline, Judge said. It was a defense exhibit, and then we wrote on it as well.
Oh, yeah.
Not great handwriting.
Got a little crazy.
You guys were having a party with that exhibit.
No objection.
Okay.
I mean, S 477 was the DNA worksheet with the reference samples. I don't know. I mean, I know we're having expert testimony coming too, so I don't know what defense plans I'm using.
477?
Yes.
Can you put that on the screen, 477?
Judge, we didn't have an objection to that.
I guess if we're not putting in reports though, we probably wouldn't need it from DNA.
As it relates to some of this stuff, if something becomes relevant as a result of the expert on Monday, you can let me know.
Sure.
But I want to stay consistent that reports are not coming in. It's just the testimony as it relates to that. But if that becomes relevant, you can let me know.
We don't have, so there were two exhibits a few exhibits that we had that were marked up.
Right.
The state did not have an objection to. It was like an allele table.
Right. I don't have a problem with those. I know what you're talking about.
And the two deconvolution reports. So I don't know if if the state had something similar, we wouldn't have an objection. We just had an objection to each and every DNA report that they originally, I think, were.
All right, let's do I know you want to argue the other part for the D exhibits. I don't want to do that right now. But as it relates to, for purposes of what you did on cross, as you highlighted the results page, I don't have a problem with that because I think that would be demonstrative and helpful to the jury, however they want to use that. So that I would make as an exception to the ultimate reports. But I'm not sure about the deconvolution report. We can talk about that in a minute. But Ms. Wallace, you're looking like I'm saying something wrong.
No, Judge, it wasn't you I was thinking about. The next
okay.
exhibit on the list is an electropharogram, which I don't think that's going to become relevant.
Well, why don't we wait on that? Because I'm not going to rule on that until I hear from Reich. Right?
Understood.
Yeah, I think in general, Judge, though, the electropharograms and the allele charts and things like that, we're not going to have an objection to that because we're going to be using so much of that, I imagine, during the.
If you guys all want it in on both sides, then I'll make an exception to the rule on this, or my rule, I should say, on this. If you guys want that, I'm okay. But I don't want you to assume though that if we allow something like this in, I'm not sure about the deconvolution report because I do remember that from the prior hearing. Remember a lot of testimony about it, so I have to take a look at that again. But if you don't have objection to these items and for you to use what you've already used, I have no problem with that.
Yeah, I think we kind of anticipated that this was going to be something that was in front of the jury, and we don't have an objection on specifically talking about 478, 479, 480. We don't have an objection to those.
478, 479, and 480, you have no issue with it?
No.
Judge, I think we should take a look at this stuff because I think what we're doing here is we're putting in potentially deconvolution reports just because someone put a circle around it, but we're not giving them DNA results. So the idea that it's just in a vacuum, I think we have to look at what is relevant because obviously no one's going to remember 460 septillion versus 4.1 octillion.
They're not?
I doubt they are. I think the idea is obviously there's certain pieces of evidence that are, you know, obviously relevant and probative. But I think we'd have to look at this because, like, I looked at Ms. Mastalone's stuff earlier, thinking that maybe they were gonna get certain things. Now, obviously, that voting table, we obviously have no issue with it. I think we wanted to put it in too, and we can do that without putting in the whole report. But I think there should be at least some sort of summary of stuff like that.
All right, we're gonna reserve on 476, 477, 478, 479, and we can come back, and 480, we can come back to it.
And that's fine with us too, Judge. Like, we're not trying to, we can also talk it out and see if we're on the same page with what the jury should have. Like, we're not trying to
I respect that.
suggest that our stuff should be in and their stuff shouldn't.
I respect that. Okay.
The rest up to, looks like up to 493 were either the DNA lab reports or there was one other DNA lab reports. So, I want to, again, lump those in with the discussions that we're going to have, or?
Yeah, we'll hold off on the DNA stuff until after the defense is concluded. And then, and out of fairness, I should say this to both sides, that if you don't move something right now, if something becomes relevant after today, obviously I'll revisit it. So I don't want you to think you're precluded in any way. I would never do that. So let's come back to the DNA.
That takes us all the way up to 501 is the only, I think the only non-DNA one that's left.
And that was from today. That was the photo of Mr. Caneiro and his daughter?
Yes.
So that we would object to because I thought the witness didn't lay the foundation. He said he didn't know when it was taken. He said he couldn't say. He said he couldn't remember if that's what Paul Caneiro looked like at the time of November 2018. I think based on our sidebar conversation, my understanding was that if the witness was able to lay the foundation and I guess connect the relevance to the case, then the court was going to allow it. But it was never published because I think the witness wasn't able to do that.
Mr. Decker?
Well, obviously, Judge, we had to deal with what we had to deal with because the part of that photo was also, I believe, her photos similar to that were also in the phone. Obviously, I know where I got the photo from, but I guess I'll defer to the court with respect to the testimony thus far in that regard.
So this is what I want to do. The one thing that I do want to, he did talk about how the age of the daughter, but I want to go, I don't remember exactly the context, so we're going to go back, we're going to listen to that. You guys feel free to do it also. That would be the only thing that may give it context to around the time frame, but I agree with Ms. Mastalone. Otherwise, he was non-committal as to the time frame of when the photo was taken. So let me just look at the testimony on that. We'll make a final decision on that.
Just to put it into context, I think my recollection of the testimony is he said she was in her early 20s. At the time of November 2018, Katie Caneiro, the older daughter, was 26.
Okay. All right. So, and that, yeah, I think you're right. That's the exact words that he used. So I'll just take a look at it one last time and then I'll rule on that. Sure. All right, let's go to the defense exhibits. I'm working off of, on the defense exhibits, just the document that you gave me maybe a week or two ago. Is that the document we're working off of?
No, we have a much more updated version, Judge.
So as far as actual exhibits, we did publish several during the DNA.
Before we get started, can you send by way of email right now?
Yes.
The updated exhibit list so I can print it out and have it in front of me?
Yes.
And send it to the state? We'll make a copy for the state so everybody has it.
Can I use the bathroom over there?
Go ahead, of course. You can go, no, better not go in the jury room. Anybody else need to use the lavatory? Everybody okay? There you go.
I'll tell you later.
Yeah. What did you expect? What is that?
We're gonna stop at 5 and then we'll pick up Monday morning. I'm sure Mr. Decker has a game to get to.
Phil, give me tomorrow.
Mr. Murray probably doesn't want to hit any traffic on the way home.
Whether I do or don't.
It's happening. How's it been for you? I forgot to ask lately, sorry.
No. I mean, it's actually not. The summer was worse. Significantly worse in general. So.
I'm sending it right now.
Sorry, thank you.
No, you're fine. We're waiting. Mr. Murray's just emailing us. While we're waiting for that to print out, let's go over to the, I said, Ms. Messalon, when you were out, that we're gonna stop at 5, no matter what. So let's just, let's go over to the jury charge for a minute while we're getting the printout. There was a couple of things that I saw that I wanted to make sure that I told you about. And then we would make those corrections. All right, so jury charge, as it relates to, it's no issues with the general information, nature of indictment, presumption of innocence, burden of proof, reasonable doubt, function of court, judge's questioning, function of the jury, all of that is a model. Same with direct and circumstantial. But I wanted to confirm with you on the top of page 7, can I take out the highlights now and it's just the Petrozzillo stipulation, right? That's the only one we're gonna have?
Yeah, I think that's the only one that needs to be read to the jury.
Okay, so I'm gonna cross out lines 1 through 3, but it has that in there. I'm gonna take the number 1 out of there, so it'll just say during the testimony of Lieutenant Petrozzillo. That's the only thing it's gonna say in that paragraph for stipulations, and I'm not gonna just change it to stipulation. Credibility of witness is model, identification, fine. I wanted to go to my notes. Abraham was, Abraham after Schlenker? Yeah, here he is. He is,
I think it was Monday, she was.
electrical and electromechanical engineer matters and cause and origin of fire and explosives was what he was accepted as an expert. So we'll add that in there, into that section. And I'm gonna take out on line 24, where it says the defense called, that, I don't think that's necessary. It should just say Carl Reich in the field of forensic DNA analysis, unless you want me to specifically say the defense. I just didn't want it to look like the state has all these and the defense has defense has one. I thought it would look cleaner if we just said it that way, but if
No, that's fine, Judge, yes.
okay. All right with that, so we'll fix that. Do that. Nothing on the narration, I think that's fine. Defendant's recorded phone conversations are fine. Limit instruction, certain evidence, fine. Witness prep is fine. Third-party guilt, page 15. line 3, I'm just going to cross out, it says his/her, I'm just going to take out the her portion. And then on line 9, it just doesn't have a period at the end of it, so I'm just going to put that in there. On page 16, lesser included offenses, line 4, that first line, I'm just going to change it to included instead of inclusive offenses. And I'm just going to change it to lesser included offense. Ms. Mastalone, for the record, I should say, Ms. Mastalone requested the court to consider a lesser included charge, a third-degree theft charge. And looking at the gradation, it was the court's position that the grading will be the amount of whatever they check in what box, so it's not really on a lesser included offense per se, it's just whatever number that they come up with, whatever range they come up with. So I was not going to make that a specific thing, because it's really depending on the money, and I didn't want to confuse them as to different money would have a different level of crime. I just wanted to make it generic. You tell us what range that you're finding, if you find him guilty at all. So that was the reason why that I didn't think that that was necessary, but I wanted to give you the opportunity, considering you put it into an email, if you wanted to put something on the record. If you think I'm wrong, you can. Go ahead.
Just have one moment, Judge.
Sure, of course. Here's the model charge, so that's what you're going to look for.
Actually, we're just looking for the verdict sheet to see how it matches the...
Oh, the verdict sheet? Okay. I have that up here too, if you don't have it. Yeah, as soon as I can find it. It's here somewhere. I had it on my right. Here we go. Let me just get to it for everybody. So it starts with question 13. It's right there on the bottom.
Okay, yeah, that's fine, Judge. We, at the time that we sent the email, we weren't looking, we didn't have the verdict sheet. We were just looking at the charge.
Okay.
So that makes, I see how it corresponds. Thank you.
Okay, sure. All right. So we'll leave it that way. All right, so that's that. We'll just fix that, clean that up. Like I said, with the murder charge, after I read it, then I'll give them the verdict sheet and we'll go through it line by line to make sure that they don't have an issue. I want to go to the felony murder. If we can go to page 25 at the bottom. Is everybody there?
In the jury charge, Judge?
Yeah, in the jury charge. Line 29 starts with number 1, that on or about November 20th, 2018. You see that?
Yes.
All right. So if we just continue on, the defendant was engaged in the commission of or attempt to commit or flight after committing or attempting to commit the crime of arson. And then it says, as charged in count 7, but that's not accurate. It should say, as noted as a lesser included offense to count 7. Because they're not alleging in the felony murder aggravated manslaughter, which is count 7. It's only arson. So with that being the case, I have to clear that up. So that's the way I was going to say it. So it would say, instead of charged in count 7 of the indictment, it will say, as noted as a lesser included offense to count 7. and then I still lay out the elements of arson when we get down, starting on line 10 of that same charge. And if you look at number 1, which is on line 12, it should not say, it says that the defendant purposely started a fire, and it says on his own property at 15 Willowbrook. It should not say on his own property. It should say started a fire at 15 Willowbrook Road in Colts Neck, New Jersey. Does anyone disagree with those two changes?
No, Judge, we don't.
The second one, no, Judge. The first one, I'm sorry, I didn't quite follow.
Okay, so count 7 of the indictment charges the defendant with aggravated arson. Same thing with count 8. When you look at what the felony murder indictment, when the state does the indictment, it's saying that these crimes occurred in the flight after committing or attempting to commit the crime of arson, not aggravated arson. So they don't have to prove aggravated arson for it to be a felony murder. They have to prove arson. So that's not the actual charge in count 7. It's actually the lesser included of count 7. So that's why that I'm saying that it's the lesser included charge, so they don't get confused of going to count 7 and looking at aggravated arson, because that's not what they're saying in the indictment. That's not the allegation. That makes sense?
Does.
You can look at it. Take your time. The next one that I observed was the page 31. It's a minor edit. It's just should say lesser included offense. It's not offenses because it's just a 1 for arson.
Can I make a suggestion?
Yeah, of course.
I'm sorry. I think maybe it could just say commit the crime of aggravated arson or arson.
Where?
In what we were just talking about, the
Felony murder?
yes.
They didn't present aggravated arson to the grand jury, so he's not, that would not be what the grand jurors decided probable cause for, is aggravated arson or arson for that count. They only found the arson for that count. If you want to think about it over the weekend, Ms. Maslone, I don't want to force you. You can look at it.
Sure, Judge. Yeah, my concern was just that I didn't want to confuse the issues if they were to find Mr. Caneiro guilty of only an arson, that they were under some misimpression that, that's when they would find him guilty of the felony murder. So I just wanted to.
But that is true, though. If they found him guilty of just arson, that would be enough for that element of felony murder.
Right, I understand that, and okay, that's fine, Judge. Yeah, we'll talk it over and just.
Yeah, digest it over the weekend, but that's the way I read the indictment. Am I wrong, prosecutors?
No, you're not wrong, Judge.
Okay, so you guys can let me know. But that's, as of right now, that's the way I read it. Count 9, we're dealing with possession of a firearm, It's on page 33. I had wanted more information, more testimony before I made the decision on whether there was some evidence to support the possession of a weapon for unlawful purpose against Jesse Caneiro and Sophia Caneiro. Ms. Maslone, I'll give you a chance to argue it. I'll tell you so that you know what I remember of the testimony so that you can address it if you'd like. Or Mr. Murray, I apologize. Mr. Murray, if you want to respond. I do find, based upon the medical examiner's testimony, that because one of Jesse's injuries could have been from a gunshot wound, that I do not have an issue with including him. As it relates to Sophia Caneiro, based on the fact of the testimony, if you put all the testimony together, that Sophia's blood and Jesse's blood were found in the kitchen area, that and the shell casing was found, was it the shell casing or projectile in the kitchen area? Projectile was found in the kitchen area, that I do not have an issue with leaving Sophia Caneiro in, because it's an and/or, so it only needs to be one of them. And obviously, Keith Caneiro suffered multiple gunshot injuries, and Jennifer Caneiro suffered a multiple gunshot injury. So that would be my position. So I'll give you a chance to argue against that if you disagree with me, but that's what I recollect from the testimony.
Judge, when we submitted our like corresponding comments for the previous draft, we just said we defer to the court.
Okay, all right, so as long as we're fine, then I'm going to allow that. And we're going to just take out that highlight, which will then take out the highlight on page 36, line 7. I want to go to count 10. The court,
Judge, I don't know if it makes your life easier, but we did intend, before we rested and kind of forgot, to dismiss count 10.
okay, so count 10 will be dismissed, so that will be taken out of the charge. So that's page 36, 37, 38, up to line 19. Okay. So starting with, now we're talking about the knife on count 11. Line 20, we have to add in the exhibit number, which we've already mentioned is 313. Am I correct, state that that's the exhibit? Because that's what we originally talked about in line 14. That's 313.
I believe that is the number.
It is, yes.
Okay. That was the only thing that I saw as it related to that particular count. Is the state still continuing with the unlawful possession of the knife on count 12? Or, I don't care, I'm just asking because of what you said about count 10. It doesn't matter to me, I'm just...
Judge, I think we are going to keep that one on the indictment.
Okay, it's fine. So with that being said, I didn't have anything else to add as to that count or any of the, anything there. And just to move it along, I don't have any issues through the end of it, because it goes through the theft charges, the hindering charges. I didn't see anything. I'll scour it one more time over the weekend. I'm sure you guys will do that also. The last issue as it relates to the charge, and then we'll get to the last proposal by the defense, deals with the addition that was made by the defense as to what happened in sidebar or what happened in open court. The defense asked for something to be added. Obviously, it's within the draft. It has been marked. This draft has been marked so that the proposal will be on the record in its entirety as to what was requested. I don't disagree, I don't agree with what, all the things that are in here. What I would do, Ms. Mastalone, is I will tell you this, that when I do the beginning part of the charge and I talk about objections, I will remind them again of what I reminded them of early on in the trial, to deal with the fact that any communication between counsel, between me and counsel, or anything that happened in sidebar must not be considered for any reason, for any purpose. But I don't see myself reading your specific request. But if you'd like to put something on the record, you can. But I will expand a little bit as it relates to that issue right under function of the court on page 3 at the bottom when it talks about sustaining objections and ruling on admissibility of evidence. I will talk about it a little bit there. But I don't see the need to put all of that in writing because I don't think that that should be something that should be highlighted. But go ahead, if you want to put anything else other than what's already there.
Judge, just that originally the draft that the court provided to us at the very end of it had the word sidebar bolded. So I thought that the court was asking us to propose a charge. That's why my comment said.
I'm sorry. The sidebar was, I bring you guys to sidebar to see if there's anything that I missed in the charge. That's what I meant by sidebar. It wasn't for something to be added there. I apologize.
Okay, yeah, my original comment said, is the court seeking an instruction on sidebar? If so, this is what I would propose.
Okay.
And what I proposed was, I thought, relatively neutral. I think, given the unique structure of this courtroom, I don't know, the jury is very close to the bench, and I know that, there were a lot of sidebars in this case. So the instruction, I know the court's indicating it's going to be part of the record. If I could just read it briefly. During the course of this trial, there were numerous occasions during which the court conferred with the attorneys at sidebar. The conversations are a normal and necessary part of trials and are designed to address various legal, procedural, and evidentiary issues that arise during the trial. You must not speculate about the subject matter at any sidebar conference, nor should you draw any inference or conclusion from the fact that a sidebar occurred. Neither should my rulings that result from these conferences be taken as favoring one side or the other. Additionally, you must not consider or evaluate the demeanor, tone, or manner of the court or the attorneys during sidebar conferences for any purpose. Judicial rulings, comments, or demeanor during legal discussions are not evidence and are not an indication of how the court views the attorneys, the facts of the case, the credibility of any witness, or the guilt or innocence of the defendant. It is also important to note that attorneys in this case are tasked with providing zealous advocacy, which includes raising objections, making legal arguments, and addressing issues at sidebar to ensure that the trial is conducted fairly and in accordance with law. I think the last paragraph is a little bit redundant, but so I'll skip over the last paragraph, which basically just says ultimately the verdict must be based solely on the evidence and not on anything observed at sidebar. I thought it up because I thought that the court was asking for a proposal, and then as I was thinking it through, I just thought maybe, again, I was assuming that the reason why we perhaps wanted it was because there was a lot of sidebars and because there was a lot of interactions. And even today, I know the court excused the jury momentarily while we had a sidebar because there was a concern, are they paying attention? Are they looking? Can they hear anything? So that's why it was proposed.
Mr. Decker or Ms. Wallace, do you have an issue with the first two paragraphs? I would move it up to under the function of the jury. I'd weave it in there. Function of the court, on page 3. If you don't have a problem with it because of where we I can read that in. I I don't like to highlight certain things because I don't want them to say, well, they're telling us not to, and I wonder why. So that was my concern, but if the state doesn't care, then
I think I agree that I just don't know that you need to be adding, again, I've said this before, I don't know that you need to be ad-libbing into something that is generally within the function of the court as part of a model charge.
all right, let me think about it over the weekend. I plan on saying some of this so that everyone knows. It's rare, it is rare, but there are times that I'll go off script just to provide some, and what I feel is helpful information to illustrate something, but it's not that often that I do that. That would have been something I would have done here just to make it clear to them. But let me think about it over the weekend. So before I just flat out say no, I will think about the first two paragraphs, Ms. Mastalone. I'm going to say, I think the third one is redundant, I agree. I'll take a look at it one more time, and we'll go from there. So the last thing, though, we'll do that, is the last request, which candidly I was confused by, is for the ballistics related charge. I do not see how any of this was either testified to or something that should get before the jury. This is not a model charge in any way, shape, or form. I'll read it. In this case, you heard the testimony of a witness, Christopher Clayton, who claimed special qualification in the field firearm tool mark analysis. And first of all, he was an expert, so he's not claiming anything. This witness has offered an opinion that bullets labeled 11, 12, 17, and 20 were identified by him as being fired from the Sig Sauer barrel marked as S-176. The witness also offered an opinion that the shell casings labeled 13, 14, 15, 16, 18, 19, and 21 were identified by him as having been discharged from the Sig Sauer pistol marked as 193. When evaluating this testimony, you should know that the method used in this case, AFTE, provides a broadly stated framework for conducting tool mark analysis. However, and then wants to cite to the President's Counsel advisory, which was not a part of this case at all. However, this framework is not specific enough to qualify as a validated method for this type of analysis. That's not testified to at all. You should know that the analyst employing this method must make subjective assessments through the process. He testified that they were subjective assessments, but I don't think that belongs in a charge. You should be aware that regardless of what preconceptions you may have about the infallibility of firearms and tool mark analysis, this method is not infallible, as errors can and do occur with any judgment-based method. And again, so citing to this advisory that none of this was not brought up by Mr. Murray on cross-examination, nor was it cited as it's in this charge. Any conclusion about the accuracy of the method must be based on what the empirical scientific evidence support, and not on the analyst's personal experience or degree of confidence in their own work. Any statement by either the witness or an attorney implying the infallibility of this method or a chance of error so remote as to be a practical impossibility is not scientifically valid. So you can argue it. I just put it on the record so you don't have to read it, but I don't see it. But go ahead. I want to give you the opportunity to argue what you want to say, and I'll hear from the state, and maybe you can change my mind.
Judge, yeah, so this one I did not personally draft. This is sort of an extension of the the pretrial hearing that was conducted with ballistics, and I think a lot of this was really argued pretrial. So with that in mind, my understanding is that this is a charge that is being requested in cases such as this where there's like ballistic matching and the purpose is to kind of educate the jury on the limitations as, you know, as we see it, I guess. So the charge is not, you know, I'm not the first person to ask for this charge.
Right.
I think it's been requested in other cases. I don't know whether it's been ultimately given. I could ascertain that information if the court wanted to know. But I think given, again, just the context of the pretrial litigation or within that context is the court denied the motion, right? So our next request would be like this mitigating measure with respect to the charge.
Okay, I understand. Mr. Decker?
I mean, just very briefly, it's just nowhere near supported by any testimony from Sergeant Clayton via direct or cross-examination. We're citing to the PCAST. If Your Honor would have given this charge to yourself over the summer, that might have been appropriate in the sense of like that's where the testimony about this type of stuff was, but not in front of this jury.
Yeah, I understand and it will be a noted objection on the record. The court rendered its decision as it relates to this ballistics expert testimony. I allowed it in despite strenuous objection by the defense. This is something that a reviewing court, if the defendant is convicted of anything here, would be able to review. I do not find under these circumstances that anything within here was really testified to. Mr. Sergeant Clayton was not confronted with the PCAST report or was any of this really discussed. So I'm not going to allow this charge, but it will be kept preserved for the record. What I'm going to do is, if you don't mind, let's make sure that we mark this charge that was requested firearm and tool mark evidence so that the record has it for Ms. Mastalone for any future event. What C exhibit are we on right now? Do you know? Actually, it should not be a C exhibit. It should be a D exhibit.
Hang on. Wait.
It should be a D exhibit. So let's mark that as, you stop at 122, Mr. Murray?
45, I think, is their next number from the list we got.
I'm sorry, in terms of our exhibits, we're at D145.
I only have up to 122.
You have,
Maybe it's on a different page.
you should have it up to 143 because that was shown by Ms. Mascalone during the Daniel Reed's presentation.
Oh, okay. So this would be D145. And I'm going to mark D145 so that a reviewing court would have that.
Oh, okay, thank you. I'll add it to her.
Yeah, so let's add that. So we make sure that it's all in there for the future. Okay. So with that being said, anyone else have any other issues with the charge? Because what I'm going to do is, over the weekend, my clerks just learned that they have to work over the weekend, that over the weekend, we're going to send you back the final charge. And we'll have the watermark still on it saying final, but if you have some issue with it, you can let me know, and we'll talk about it on Monday. But make sure that you get that before Monday morning, and you have time to review it. Hopefully, we can get it to you sometime tomorrow, so you can have it for Sunday to read while you're having appetizers for the Super Bowl. Anyway, let's go to the D exhibits. Mr. Murray, go ahead.
So, Judge, the first one that we published to the jury would be 55.
55, okay.
The group text with Ben, Keith, and Paul.
I think that was just that was a more complete version of what we had shown, so we don't have any issue.
Okay, so 55 is in evidence, or will be, I should say.
The Canada Life full payment history was D64.
No issue.
Okay.
D71 was a portion of the Merino body-worn camera starting at 3156.
We looked at all the photos. I didn't have any issue. We didn't have any issue with any of the photos. I just didn't. Was that included in the stack of photos?
That's a body worn camera. That's
This is the body worn camera, it's another part of it.
But we have.
Is it a screenshot?
No, we had played some, remember, so we played some, it was
Yeah.
already published to the jury,
Yeah.
but we didn't have an opportunity to confer with the state on that. I mean, I can provide them with the videos over the weekend and they can take a quick look, but it's all stuff that was played to the jury.
No, that's
Yeah,
fine. That's fine. No objection.
Okay. Yeah, I don't see the issue. If it's already been played, it's a body worn camera. All right, so D71 is good.
71.
You said, I thought you said 71.
Yes, D71.
Yeah.
Yeah.
That's good. You're
Okay.
good with that.
All right, and then D71.1 screenshot photo of the refrigerator.
No issue.
Okay. And
And then the next exhibit would be 106.
the other body worn camera for Redmond.
No objection.
Okay. And again, so everyone is clear, body worn cameras, if they want to see it, if the jury wants to see it, they're going to have to come back out here. We have to play it out here in open court. Mr. Caneiro, you'll be here if they want to see something like that, okay?
So then D114 would be the video of 44 Willowbrook from 2:46 a.m.
Isn't it already in, or no?
I think it was no, because it was a separate video, that exhibit that we had played at 20:34:10.
Oh, this was much earlier.
Right.
Okay.
This was the other. I'm sorry. So the timestamp should be 20:34:10.
Yeah, 8 o'clock at night.
Yep. Right. Right.
No objection.
All right, so that's in.
There was the email that was published to the jury, D122.
It says email between Paul Caneiro and Sense.
Sense is the company that he was corresponding with in that email.
Oh, yeah, I remember.
To Detective Magarisi.
I remember.
Yeah.
Yeah, there's no issue. We didn't object then.
Okay, that's it.
The remainder of the, no, yes, they are. So starting at D137.
Okay. Let's hold the DNA stuff until Reich is done.
Right, so the rest is DNA.
All right, so let's talk about the photos. You guys have looked through those, or do you still need more time, Mr. Decker?
Defense photos?
Yeah.
We have no issue with the photos. I mean, they're getting a lot of redundant photos like we've talked about, I think, but we don't have any issue. Yeah, but we don't have any issue with any of the photos. There's nothing wrong with it.
If you guys want redundant photos in there, I'll do it. I humbly, I just think we're confusing them by doing that. But if you guys want your own exhibits in, I have no problem with it. So if you want them in, do you know which ones you want to put in?
We have it, so we have the full list. I think what would be probably most helpful for the court, I would imagine, is if I go through that tonight and take out the places, the photos we're not using,
Okay.
the ones we didn't show, so you can just have a list of everything that's in.
Perfect. You can do that, and just have me, if you can send it to us in a PDF over the weekend, we'll look at it, and to the state, and as long as there's no issues, then we'll be fine with that. And you figure out, Mr. Murray and Ms. Mastellone, but you guys figure out how you want to give that to the jury. I don't care. That's up to you guys.
Our intention is to just give them the photos.
That's
That's why
fine.
we printed them, but also, if the court, we could do like a one-sentence instruction and just say, you may notice that some of the state's photos and some of the defense's photos are duplicative. That's...
Somewhere in the charge?
Yeah, I think that's fine, like, just to avoid any confusion as to why they may see, like, you may observe the same photo twice, it's because both the defense and the state submitted the same photo.
That's a good point. I can do that. That's not a problem. I'll do that. Okay. Anything else as it relates to the evidence? How about the verdict sheet? Did you guys have a chance, did you say you didn't have a copy, or you just didn't have one handy at the time?
We have one.
We
Okay.
didn't have one handy at the time that we were looking at the.
Okay. So does anybody have any issue with the way that this is laid out, or how, I think we've gone over this a few times, but I just want one last chance.
No issues.
No?
Just judge.
But if something happens over the weekend, just shoot us an email over the weekend so we can clean it up, and we'll do that. Okay. Anything else that we need to discuss right now, or does everyone think we're good?
I can't think of anything, Judge.
Okay. From the defense?
Nothing to add, thank you.
Okay. All right, so we are concluded for today. Monday morning, we'll be back here at 8 o'clock, and we'll start with testimony at 8:30. Everybody have a nice weekend. Please be safe.
Good, Judge.
Sorry, one other thing. We need to figure out, remember we were talking about this evidence, and when you guys give me your final version, when you put it in the SharePoint, how we want to do that.